Number 10, my lord, criminal appeal. Can this be taken up on Tuesday, my lord? I need some more time to prepare better. Criminal appeal, 302, sir, conviction case.
Item number 10.
10, my lord. On Tuesday, my lord, there will be a deal.
Okay. Next is
Yes, if
on the appeal being made by Mr. D. Pagni, learned counsel for the appellate, having not been opposed by learned additional PP. Any objection?
No, Lordship.
The matter stands adjourned to be listed on Tuesday.
problem.
Obliged.
May I please, Your Lordship? Lordship, in item number 1, my lord, this morning only we have filed, my lord, the affidavit in opposition, my lord.
Okay.
So therefore, my lord, our affidavit in the opposition filed today may be called for, my lord.
Today.
My lord, since matter is in item number 1,
Yes.
my lord, since we have already filed the affidavit, that may be called for, my lord.
Okay.
May I please, my lord? My lord, I have also filed an IA in item number 1, so it may be called.
Develop.
Obliged, my lord. Please, Lordship, may. Lordship, I beg to mention item number 9, Lordship.
9.
Yes, Lordship. Lordship, here I am for the appellant, Lordship.
You are for the appellant.
Yes, Lordship. Lordship, the conducting counsel is currently on bed rest due to sleep desk problem. And the matter may fix after 3 weeks, Lordship.
Mr. Your name, please?
T. Tato.
T. Tapak, learned counsel for the
So, Lordship, T. Tato.
T. Tato.
Yes, Lordship.
Learned counsel appearing on behalf of
M. Biswas, Lordship.
M. Business.
Yes, Lordship.
Conducting counsel for the appellant. With consent from the other side, press for listing the matter
3 weeks, after 3 weeks, Lordship.
after 3 weeks.
Yes, Lordship.
Why 3 weeks? Sir, this is criminal appeal pending since 2021.
Lordship, this is what I have received instruction.
Pardon?
This is what they have instructed me to take the 3 weeks, Lordship. Since
We are allowed to recess the matter after 2 weeks, not 3 weeks.
obliged, Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, with consent from the counsel for the respondent side, I'm praying for the adjournment of item number 8 on behalf of my senior, Mr. R. Soikia. Kindly, this matter may be listed after 2 years.
Mr.
Ibam.
I, Bam, learned counsel appearing on behalf of Mr. R. Soikia, learned conducting counsel for the appellant. Any objection for the other side?
No, Your Lordship, I have taken consent from
Okay, with consent from the other side, press for listing the matter
after 2 years.
after 3 weeks. After they are allowed.
Much obliged.
May I plead, Your Lordships?
Yes.
I beg to mention item number 11, my lord. Here, my lord, here my Advocate General will be appearing, my lord. So this matter may be fixed after bihu break, my lord. I've taken consent.
Yes, I'm for the appellant in this case. No objection.
That's all right. No objection.
No, Your Lordship.
Ms. Wangmo, learned government advocate, appearing on behalf of the learned
State
Advocate
response.
General.
Yes, my lord.
Press for listing the matter after due vacation. The pair having not been opposed by Mr. Elbam,
Ibam.
Ibam, learned counsel for the petitioner.
Yes.
Petitioner. The matter stands adjourned to be listed after due vacation.
Yes, obliged, my lord.
Much obliged.
Yes.
Item number 1.
Now that call that
Yes, I have
affidavit
already sent in the register. I have already sent.
My lord, if
after some time.
after some time,
Okay.
yes.
Item number 2.
Yeah, Your Lordship. Lordship, this IA has been filed by the Commission, APPSC, Secretary APPSC, Your Lordship.
Mm.
In the IA, they have, the petitioner opposite party has filed the objections.
Mm.
And in the main writ petition, Your Lordship, I have already filed my affidavit in oppositions.
Mm.
In the IA, I have praying for modification of the order dated 21/1/2026, Your Lordship, whereby this honorable court has directed the commission to seek prior information, prior permission to issue fresh advertisement, Your Lordship. So, Your Lordship, if this IA is considered, then the entire writ petition will go, Your Lordship. So in that,
We can hear both the matter together.
yes, Your Lordship. So in that,
Are you ready to argue the matter?
otherwise also the government, they have not filed the affidavit of oppositions.
Should we need time, Your Lordship,
Your
to file
Lordship.
affidavit? Instruction we have received, Your Lordship. We need some time, Your Lordship.
May I pray that in the meantime, government may file the affidavit and this matter may be fixed for hearing, Your Lordship, on 9th of April,
Lordship.
9th of April.
Lordship.
Yes.
Lordship.
Heard Ms. Onjo, learned counsel for the applicant. Mr. Lampo, learned counsel for the opposite party number in the IA.
To all man. Papoma is the man. I'm appearing for all.
Opposite party number?
One
Opposite 1 to 9, Your Lordship.
1 to 9. And also heard Ms. R. Basar, learned counsel, learned government advocate for the respondent number 10, 11, and 12.
Lordship.
10, 11, and 12. Ms. Basar submits that she may be granted some time to file the counter affidavit in this matter, and she has already received the instruction. Ms. Onjo, learned counsel for the applicant, submits that this application may be heard together with WPC number 549 of 2025. And it may be listed on
9th of April.
9th of April. The pair having not been opposed by the learned counsel for the opposite parties. This matter stands adjourned to be listed on 9th of April, along with WPC number 549 of 2025.
They are supposed to file in the writ petition, Your Lordship, the affidavit in opposition, not in the IA, the government.
This,
IA, they are just a performer party,
okay.
but government are supposed to file in the main writ petition. They-
Affidavit.
Yes, Your Lordship.
Okay. Ms. Basar submits that she will file affidavit in opposition in the WPC number 549 of 2025.
Obliged.
Item number 3.
May I please your option? I am online, my lord. My lord, in terms of the order dated 17/2/2026, steps were directed to be taken on restaurant number 14, 20, 21, 22, and 34. Accordingly, my lord, we have tendered notice through Dosti mode. And to that extent, my lord, I have also filed affidavit on 15/3/2026. Therefore, service is complete, my lord. In the meantime, my lord, government has, my lord, accepted a draft service rule. Our whole contention before this honorable court in respect of my lord writ petition is a particular post, my lord, director or deputy director of elementary education is a promotional post, and we are holding the, my lord, post of BO. Therefore, we are eligible to be promoted to the post of DDEE. Now, government has, my lord, allowed director of secondary education to hold all the posts which are sanctioned and created for elementary education. Because after the creation of, my lord, new directorate in 2010, original directorate was bifurcated. My lord, in two directorate, director of elementary education and director of, my lord, secondary education. Subsequently, my lord, posts were sanctioned. 16 number of posts were sanctioned for, my lord, for in district level, and 4 posts are in state level. Government now, my lord, in earlier expedition, we have challenged that action. Then, my lord, at the time of admission hearing, they brought on record an amendment rule of 2014. And in terms of that amendment rule, my lord was pleased to dispose of the earlier writ petition, giving the liberty to file the present writ petition challenging the rule. Now that rule, 2014 rule, is under challenge. And at the same time, my lord, we have filed a miscase to bring on record the draft rule. And it was accepted by the court to be part of the record without any objection on the part of the respondent. So this is the position. There is some urgency, my lord, because our promotion is held up since long. Matter relates to 2019. And let government file an affidavit, my lord. At the same time, my lord, matter may be heard, my lord, at an early date, subject to convenience of the court.
My lord, within 3 weeks, my lord, will file a counter affidavit, my lord. This is, yes, my lord, I'll file, my lord.
Okay.
My lord, kindly make an observation. Let it be a last chance for them, my lord. Because clients
My
are
lord,
after
it's
me.
not
my
big.
lord.
I'll file it, my lord.
How many chances you have availed earlier?
My lord, earlier, my lord, this fact, my lord,
5, 6
this,
times.
they have brought by way of additional affidavit, my lord. So additional affidavit, I have again sought for instruction, my lord. That talk took time, my lord. And for that, after additional affidavit, my lord,
Okay, heard Mr. Professor, learned counsel for the petition, Mr. Tagum, learned standing counsel for the respondent in
my lord, respond number 23678, my lord. Standing Council of Education Department.
standing counsel, education department being respondent number
2, 3, 6, 7, and 8.
2, 3, 6, 7, and 8.
Yes.
And Mr. Riamphor?
1, 4, and 5.
1, 4, and 5. 1, 4, and 5. Mr. Professor, learned counsel for the petitioner service that service in this matter has already been completed. And he pressed for listing the matter for admission hearing. Mr. Tagum, learned counsel, standing counsel for the respondent in education department submits that he may be granted some time to file counter affidavit. Mr. Professor, learned counsel for the petitioner has pointed out that the respondent in education department has already availed several adjournments. And as such, he prays for granting last opportunity to the respondent in education department to file the counter affidavit. Taking note of the submission of learned counsel for both the parties, it is provided that there is at least the matter in the column of admission hearing. Mr. Professor suggested that
My lord, just a minute, my lord.
Can it be after Bihu, my lord?
After Bihu, my lord, on 28th of April,
My lord.
or any date in the month of May. Lordship may fix the matter
8th of
on
April.
5th of May.
28th
5th
or
of May,
28th?
28th.
28, my lord. 28, my lord.
28th of April.
March.
28th of April. In the
March.
meantime, Mr. Tagum, standing counsel for the respondent in education department, shall file the affidavit in opposition.
Deeply obliged.
I'm obliged. I'm obliged.
Item number 4.
Please, Your Lordships. Your Lordships, I am appearing for the petitioner university. In this case, Your Lordships, we had challenged the regulations of the UGC 2020 regulations, Your Lordships. On 29th of July 2025, Your Lordships had issued notice to respondent number 1 to 4, Your Lordships. Respondent numbers 3 and 4, they have appeared, but Your Lordships, respondent number 1 and 2, the service has still not been affected despite the steps being taken, Your Lordships. So my humble request would be if Your Lordships may allow me to effect Dasti service on the respondents, Your Lordships, the UGC, the respondent number 1 and 2.
Okay. Heard, Miss, your good name, please.
Your Lordships, Ms. Yuthika Pallavi.
Yuthika Pallavi, learned counsel for the
Your
petitioner,
Lordships,
Miss
if I
Wama
may
for-
submit, I have also one very small submission to make, Your Lordships. Actually, due to these regulations, the university has not been able to commence its session, Your Lordships, because we have not been able to operate as an open university. So, Your Lordships, my humble request would be if a date can be fixed, at least 9th or 10th April, Your Lordships. In the meantime, we'll take the steps and the matter can be heard, Your Lordships. That's my humble request, because we have already there has been a sufficient lapse of time.
Okay, Miss Wama, learned government advocate for the respondent number 3 and 4.
3, my lord. Only 3.
Respondent number 3. Respondent number 3. The learned counsel for the petitioner submits that they could not effect service upon respondent number 1 and 2, and she prays for granting her liberty to effect service upon respondent number 1 and 2 by Dasti mode. Where allowed, after effecting service upon respondent number 1 and 2, the learned counsel for the petitioner shall file an affidavit to that effect before this court. Rest shall list the matter on 9th
Please,
April.
Lordships. Please, Lordships, I'll be grateful.
Okay.
I'm deeply obliged, Your Lordships. Grateful.
Item number 5.
None appears for the applicant on call. List the matter after a week. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
Item number 6.
Same order.
Item number 7.
Lordship, in the item number 7, Lordship, on last occasion, Lordship, the only IA was disposed, it was dismissed, Lordship, on the ground that, Lordship, similar matter, Lordship, already pending before this honorable court in the DB bench, Lordship. So what happened was only, this order was passed only in the IA, Lordship.
Whether appeal was admitted or not?
No, Lordship, because it was withdrawn, Lordship, because, Lordship, similar matter is already pending before this honorable court.
Okay.
It is reflected in the order, Lordship, on last order, Lordship, on 3/3/2026, but it is passed only, yes, Lordship, in the IA only it is passed, Lordship.
Then why this matter is listed today?
I think because, Lordship, what I am supposing, Lordship, because in the main appeal, Lordship, that order is not reflecting. So that's why it is, Lordship, again it is listed.
IA is for what purpose?
They, for condon, Lordship, they have filed,
Condonation
yes,
of
Lordship.
delay.
Yes, Lordship, but it is not admitted, Lordship, because it's already pending before this court, Lordship, the same similar or similar matter, Lordship.
No, that's all right. But here, the appellant in the other matter is same with this present appeal.
Yes, Lordship. Yes, Lordship. Not, Lordship, this council not same, Lordship. Council is different.
Different.
Yes, Lordship.
But
Appellant same, Lordship.
appellant is same.
Yes, Lordship. I have the, Lordship, order also, Lordship.
Okay.
That pending matter, Lordship. Here, Lordship. It is pending in the criminal appeal, jail appeal, Lordship. It is 7/2023, Lordship.
Okay. Brother, we may direct this matter tagged with the other matter.
Right. Says that already admitted. Third paragraph. But the jail appeal has already been admitted earlier. Can be taken.
None appears for the appellant on call. However, Ms. L. Hage, learned additional PP for the state respondent present, and she has pointed out that in connection with the same subject matter, another appeal being criminal appeal within bracket J stroke 7 stroke 2023 is pending before this court. Pending before this court. And the appellant has also filed one IA being IA number IA criminal 14 AP 2026, and the said IA was dismissed by this court by order dated
3/3/26, Lordship.
See?
3/3/2026, Lordship. It will be in the IA, Lordship. Yes, Lordship.
And accordingly, taking note of the submission of Ms. L. Hage, learned additional PP, it is provided that Registry shall take this criminal appeal number 06 AP of 2026 with the criminal appeal written bracket J stroke 7 of 2023.
Lordship, it
This matter will be taken with that matter.
that, Lordship, how is it possible, Lordship? Because it's already similar matter, Lordship. Jail appeal is pending,
That's all
Lordship.
right.
Yes, Lordship.
That was jail appeal.
Yes,
This is
Lordship.
not jail appeal.
But this appellant same, Lordship, and they,
That's all right. This matter will be taken with that matter, jail appeal.
Lordship. Then on that ground, I can approach the court that a similar matter is there, Lordship.
No, not necessary.
Not necessary.
This matter will be taken with that matter.
Oh, but in the last, okay, Lordship. I must apply, Lordship.
Yes.
Item number 1.
Number one.
And on the last occasion, the respondents were directed to file affidavit to bring on record whether they have followed the JM Lindo committee guidelines or not in the upcoming elections of
Yes.
ABSU.
इसका implement type
And neither affidavit in opposition has been filed, nor the affidavit by the respondent number 3 also filed.
in fact, I have received the instruction this morning.
You are appearing for respondent number
1 to 3.
1 to 3.
I have received the instruction. We couldn't file it because the instructions was received this morning only. My
When
lord,
you are going to file?
we'll file it, my lord. In any case, our direction was state has a very limited role to play here. Our role is only to maintain law and order problem, my lord. To contain any law and order problem, and what steps we have taken that we have given in this instructions, my lord.
Mr. Kato, you are for 4 and 5.
Yes, madam.
Where is your affidavit?
Madam, this morning, we have filed. Madam, that may be called for, madam. In
Okay.
fact,
So even then, we will not be able to hear the matter since affidavit of Mr. Ratan is not available.
My lord, if my lord kindly peruse the last order dated 12/3/2026, the consideration of the interim prayer was left open for us, and it was depending on the affidavits which were to be filed by the respondents, my lord. Now,
So that's all right. If the affidavits are not available, can we consider your pair?
my lord, what has happened is in the background they have issued a notification on 17th of March, and they have in that particular notification it has been said that the elections are going to start from tomorrow, my lord, 20 to 26. That's why the anxiety, my lord.
Other is also, my lord, even if election is conducted, my lord, by completed within this week, my lord, they are not going to be prejudiced, madam.
Pardon?
But they are not going to be prejudiced. Petitioner not.
Use the mic.
I'm sorry, madam. My lord, what I'm submitting is, even if, my lord, the election is allowed to conduct, my lord, the petitioner is not going to be, my lord, prejudiced, madam. He is neither, my lord, the contesting candidate nor having any interest in the, my lord, the election process, my lord.
Okay.
That is the, my lord, and admittedly, my lord, that will be admitted by the petitioner himself, my lord. He is nowhere, my lord, going to be prejudiced, my lord.
Then why he is before this court?
My lord, maybe my lord, very three contention, my lord. Firstly, my lord, he raised the violation of the ABSU constitution, my lord. That is the first aspect. Thirdly, my lord, secondly, my lord, sorry. Secondly, there is a law and order problems in the election process, my lord. Admittedly, my lord, there is a, my lord, studio election, my lord. But that has been, my lord, taken care of by the district administration and the state government, my lord. And thirdly, my lord, application of the JM Lindo committee report, my lord, where we have categorically mentioned in our affidavit that this report is not applicable in our present case, my lord. I'll demonstrate, your lordship, when the matter is placed for hearing, my lord.
Okay.
My lord, may I submit, my lord, if your lordship permits me? My lord, there is a clear order from this honorable court, my lord, on 12/3/2026, that, my lord, Mr. Kato, he appears for Asana number 4 and 5 to file affidavit, also clarifying why Lindo committee report is not applicable. That was his submission. So the court wanted that he should come up with a pleadings as to why it is not applicable. Then, my lord, the Director General of Police was directed to file affidavit indicating the manner in which the matter is being handled and the current status. Now, my lord, they do not file affidavit, and in the meantime, my lord, contrary to what the wish of this honorable court, they have declared the, my lord, election. Now, my lord, for declaring the election, they have to, my lord, follow the constitution of the ABSU. And constitution, my lord, article 21A and 21E are very clear, and that was being specifically asked on the other earlier day, on the last date, as to why you have not followed your own constitution also. Now, constitution requires that, my lord, a committee has to be, my lord, first appointed, the election commission. That notification they have not brought on record. We submitted that there is no notification appointing one particular, my lord, election commission. Then, my lord, 15 days time is granted for giving a notification for registration. They have not issued any notification, and the registration process was on. And because of that, my lord, there was a law and order situation in the capital of the, my lord, state. And that is the reason why, my lord, the petitioner approached. Although, my lord, he's not a student. He was earlier student activist. He wants it to, my lord, function properly within the bounds of law. And the law here is, my lord, one is the Lindo Committee report. The other is their constitution. They have flouted their own constitution, as a result of which there has been large scale, my lord, unrest and, my lord, the illegal activities in the capital itself, my lord. Your lordship knows that I have annexed in my petition in the PI, my lord, the documents to show that, my lord, there were gunshots, there were, my lord, criminal elements coming in, and this, my lord, affects each and every citizen of the, my lord, state. And they are holding it, my lord, even flouting their own constitution, and that's why, my lord, this court wanted the specific affidavit from them. In spite of that, without a notification, without appointing a commission, they have, my lord, now declared the election again. That's why, my lord, and they do not file an affidavit in spite of, my lord, clear direction of this honorable court. And that is the reason why, my lord, there should be stay in the election.
Mr. Surhure, you say Mr. Kato has already filed the affidavit. However, Mr. Roton has not filed the affidavit in opposition. He has received the instruction and he pressed for granting some time to file the affidavit in opposition. Now the question is, without the affidavit of Mr. Roton, can we consider your interim prayer?
My lord, interim prayer has become necessary because of the fact that, my lord, now flouting their own constitution, they have, my lord, decided to hold the election from tomorrow. If the election is held, my lord, nothing will survive, and, my lord, this will also lead to, my lord, further, my lord, unrest in the, my lord, state capital, at least. If not, my lord, in other places, they have got this. ABSU has, my lord, their branches all over the state, and also Meghalaya, Assam, and Delhi. And yes, so they are supposed to participate, and without giving 15 days notice, my lord, they are holding the election. That is the requirement of Article 21. If I may take your lordship to the article, my lord, the constitution of the, my lord, ABSU is very clear. Your lordship will kindly come to the, my lord, page 63 of the PIL. Page 63, my lord, this is how, my lord, the election is to be conducted. Article 21, election. 1A has not been followed, 1C has not been followed, 1E has not been followed. A, my lord, is election of the Executive Council shall be conducted after every 3 years. It shall be conducted during the General Conference of the Union. However, if situation warrants, CEM shall extend the term of the office of maximum period of 6 months, and such extension will require approval so and so. Then, my lord, your lordship may come to clause C. The election commission shall be appointed by the president with due consultation of Executive Council members. My lord, this appointment letter has not been issued. The commission shall consist of 4 members, including Chief Election Commissioner, to be appointed by the President. If required, additional members will be appointed by the Chief Election Commissioner. Then your lordship will kindly turn to next page, at page 64, clause E. This is very important, my lord. The registration of delegates, has your lordship got it, my lord? The registration of delegates to prepare the electoral college of the union shall be done at ABSU office, Itanagar, or at any other appropriate place with proper notification for the convenience of students at least 15 days prior to the general conference. This notification was not there. All on a sudden, my lord, they started, and therefore, my lord, that unrest, and, my lord, all those activities, including, my lord, using guns. Prior to the general conference come election, and final voter list shall be prepared and commission by the delegates registration committee, and such list shall be published 15 days prior to the day of polling after full verification. So, my lord, this list has also not been published. So without all these, my lord, they want to hold the election from tomorrow. Unless your lordship interferes at this stage, my lord, this will, my lord, hamper the public law and order situation also. And in fact, my lord, the government earlier had withdrawn the permission given to them. Whether a fresh permission has been granted or not, that is also, my lord, not stated. Page 85, your lordship will find. 185, my lord. The government had withdrawn it. And maintaining law and order situation is the, my lord, the duty of the state. They have not filed affidavit, but they had, my lord, withdrawn this permission. If your lordship kindly comes to page 185 of the additional affidavit, my lord. Has your lordship got it, my lord?
Yes.
The last paragraph. Therefore, the permission, wide number such and such, dated 5th February 2026, granted by this office to Nabam Tamar, Chief Election Commissioner, to conduct the All Arunachal Pradesh Students' Union Election Conference at Jubilee Hall, DNGC, Itanagar, which is time-barred, stands recalled with immediate effect. So they need to get permission from the Deputy Commissioner. Whether that permission has been given or not, that is also, my lord, not clear.
Yes, Mr. Kato.
Malad. Malad, in the first line, Malad, we have already, Malad, filed the affidavit, Malad. In the first line, Malad, page 83, this document shows that, Malad, the election commission has been appointed, meaning thereby article, Malad, the 21(e)(c) has been complied with, Malad. Permission was granted to the, Malad, the Chief Election Commissioner, namely Mr. Nabam Tamar, Malad. By this later, Malad, it is very much clear. Otherwise, Malad, we have the documents, Malad, this has been, Malad, already issued. The election notification was issued long days back, Malad.
Page number?
Page number, I'm sorry, Malad, this document has not been annexed in my affidavit, Malad. This is the, Malad, the election notification issued by the, Malad, the outgoing president on 20th January 2026, Malad. By which the election commissioner and the returning officer altogether, Malad, the election commissioner, returning officer, assistant returning officer, presiding officer, assistant presiding officer, polling officer, 1, 2, 3, altogether, my lord, 8 members were appointed. And because of that reason, my lord, the permission was granted to the chief election commissioner for conduct election, my lord. And that was subsequently deferred due to, my lord, the assembly session, my lord. Assembly session was going on, therefore, that has been deferred. Now, the permission has been obtained from the district administration. We have given undertakings to the district administration as well as the Home Department that we are going to conduct election peacefully and the transparent, fairly. That undertaking we have already given to the district administration as well as the Home Department. So, law and order problem situation will not arise.
Now, my lord, let him satisfy on this, my lord, where they have published 15 days prior to the date of polling.
Yes, my lord.
The list of delegates.
That part, my lord, in our affidavit, we have categorically mentioned that this provision was not, my lord, incorporated in our original constitution, my lord. My lord, this is a student election, my lord. There are so many ABSU constitutions circulated among the, my lord, the contesting candidates, so as to take undue advantage from the, my lord, the voters, my lord, from the delegates, my lord. Therefore, the ABSU president has issued a notification saying that this all unauthorized and unauthentic, my lord, ABSU constitutions will be not applicable, my lord. The officially which the ABSU constitution has been released by the president will be only, my lord, strictly followed in the election, my lord. So therefore, my lord, that notification I have enclosed in my affidavit, my lord, saying that, my lord, whatever the, my lord, the documents and the so-called ABSU constitution which has not been verified, authenticated, and officially released by the ABSU cannot be, my lord, used in the ensuing election, my lord. Thereafter, my lord, what
So this 15 days prior notice is not there.
Not there.
actual
in the original manner. Therefore, there was so many the time taking in the process of the election registration of delegates. It took almost 1 month. Because of that reason, they have how this has been circulated, we don't know. But then ABSU, the officially released ABSU constitution does not speak about this 15 days time.
Okay.
So therefore, we are
do
also
they say that
therefore,
this is
we
the
have enclosed the 3 ABSU constitutional. We have enclosed 3
Now, page
ABSU,
76,
3
your
sets
lordship
of
will find this is a
three sets
constitution
of,
issued by them. This is the
we have enclosed in our affidavit that 3 sets of ABSU constitution has been circulated among the contesting candidates, as I have pointed out, just to take advantage from the delegates, the voters. Therefore, ABSU has released official constitution after verifying everything. So therefore, we have given strict instructions to the Election Commissioner for using of the official ABSU constitution, not from the unofficial the constitution of ABSU circulated among themselves. So therefore, we have demonstrated 3 sets of ABSU constitution, and even articles are even not tally, even not tally with the one and another. Some articles are given in the somewhere, and some articles are given in somewhere.
No, are you enclosing that official constitution with your affidavit?
Duly certified by the President ABSU, that has been enclosed, original as well as 2 sets of the ABSU constitution, which is not circulated by the or released by the ABSU office.
Okay. Yes,
very
Mr.
much clear.
Sodore?
My lord, assuming, my lord, the constitution that we have relied, although it was issued and published by the Deputy Speaker of, assuming, my lord, what Mr. Kato has submitted are all correct. Now, there is no dispute to the fact that the participants in this election will come from all over the state, from Meghalaya, from Delhi, from Assam. Now, looking at this fact, can it be imagined or accepted that by giving only 2 days clear notice, they can hold the election? If, my lord, the submission of my learned friend is correct, then they have given only 2 days notice for the election. The notification is election notification is on 17th, 18th and 19th in between, and my lord, from 20th the election will start. That means, my lord, the person in Delhi, in Shillong, in Assam, my lord, their delegates, they do not get the notification to appear in the, my lord, election and participate. Can this be, my lord, imagined that they can have a constitution like this? These are only to, my lord.
Just to answer that particular point.
My lord, this PIL, they have issued some documents, my lord. They say this is our constitution, and by that, my lord, can they hold the election in 2 days when their members are scattered all over the country?
Yes.
Maybe after a week, your lordship will hear the entire matter. Maybe in the meantime, let it come next week or the week next.
But the actual procedure for conducting election is, on arrival, the candidates are being registered. It's because we don't know the way, from which place of institutions will the students will come and get themselves registered for the voters.
Why?
So
that has to be the delegates list. Delegates list has to be published. At least not even if it on 15 days, the delegates list has to be there who will participate in the election. Where is that list?
My fair submission is the ABSU is such an organization constituent of all the students community from different institutions, even within the state and outside the state. And on arrival, the delegates will be registered, who will be the voters. And thereafter, on the spot itself, nomination paper, everything will be issued. Then after some days, if registration of delegates process is over, then declare for the holding election. That was the actual procedure. So therefore, how this has been incorporated, maybe it was the proposal made by some organization, we don't know. But then original constitution, I've enclosed the original one also. In the original the actual procedure was on arrival the delegates has to be registered. So there is no procedure for publication of advanced publication of list of delegates, list of voters. There is no procedure. It's because we don't know how many delegates will come from the different institutions. And composition of delegates is given. Earlier, everybody used to come. So ABSU being the student organization was not in a position to accommodate everyone. So therefore, that just to taken into care of that situation, composition has been fixed, and we don't know who will be the in the list of delegates. So therefore, this is the I have raised the also maintainability regarding this is student organization purely formed within the student itself. That part preliminary objection I have raised also.
Okay, Mr. Sodhuri, will you hear the matter finally?
Yes.
Let the affidavit.
If I have, my lord, if I have, my lord, if I have understood correction without a voters list, can that be done, my lord? Leave aside, my lord, the constitution. Leave aside, my lord, Lindo committee report. My lord, can a election be held without a voters list? Because list of delegates is the voters list. They do not know, my lord, who are the delegates coming, and that is how they want to hold the election. What is the purpose? They are supposed to represent all the students from all over the state and the other states, and they hold it without, my lord, a voters list. Therefore, my prayer, your lordship, my lord, let it be stayed, my lord, let the election be kept on hold for a week or so. In the meantime, DGP's, let the DGP's, my lord, affidavit also come. Your lordship will consider till then, my lord, the status quo as on today should be maintained, my lord. Once the election is held, my lord, my lord, this is my apprehension, my lord, and there will be again, my lord, public disorder. If your lordship has seen my annexes, my lord, I have already shown the documents and the news reports which shows that, my lord, there has been large scale, my lord, violence. Therefore, my lord, this is a field case where your lordship will hold the, my lord, put the election in hold for the time being, my lord, till the matter is heard.
Mr. Sodhuri, you say the affidavits of the respondents are not available right now before this court.
In spite of the
So
direction
can
of this
we
honorable
pass an interim order without their affidavit? Mr. Kato has filed his affidavit in opposition today morning. We have received the same, of course, but we have no time to go through the same.
My lord, in that event, my lord, may I pray that, my lord, even if the election is held, my lord, contrary to the held, but the results should not be declared, my lord, till the next stage, when your lordship will consider the entire matter.
It will be seriously prejudiced. On the last occasion, it was by submission, when the matter was listed on 12th of this month, I've already
It is
submitted,
not only the students, my lord.
All delegates have arrived, and they are stationed here for last almost 1 month, If lordship renews the earlier notification, election notification, it was supposed to be held on 22nd of February, Due to the registration process, it involves time for verification. Now, as per the information altogether, the registration process, everything has been done. So far, more than 5,000 delegates has been registered.
Okay.
That has been already finalized.
Okay.
So therefore, in any case, if lordship interfere in the election process, the real student, full-time students will be seriously prejudiced. They cannot they stay in the capital for long time, as I've already pointed out in the last occasion, also. So therefore, at this stage, my respectful submission will be, there should not be any interference in the election process. It has already been notified, fairly submitted by the senior council. Then notification has already been issued, So therefore, my lord, at this stage, my lord, and another, my lord, another, my lord, apprehension, my lord, if law and order problem situation arises, my lord, we have already given the undertaking. All the contesting candidate has given undertakings to the Home Department, Police Department, District Administration as well, my lord. And if any such untoward incident happens, my lord, District Administration is well enough, my lord. They deployed, my lord, the heavy, my lord, the police personnel, my lord. So therefore, there is no chances, my lord. Our, my lord, another thing is, this is a purely student organization having no legal entity, my lord. Even it can be conducted somewhere also, my lord. But however, my lord, for the convenience of the entire student community, my lord, we are going to hold the election in the capital itself, my lord. So therefore, my lord, this student, my lord, most of the students are from the far-flung areas, my lord. They are stationed in the capital, my lord, for last almost 1 month, my lord. And they wanted to go back to their respective institutions after casting their votes. So therefore, my lord, at this stage, my lord, of course, my lord, that will be decided everything, my lord. Once the, my lord, the affidavit on the part of the state and my affidavit, if it is produced, my lord, it is also not maintainable, my lord.
Yes, Mr. Rotan, are you ready to take care of the law and order situation if it arises in during the process of election?
I have placed my instructions, my lord, the preparation, what has the police personnel, home department.
Page number?
My lord, first page, my lord.
Yes.
Yeah. Number 1 is the steps taken so far to maintain law and order. My lord, may I read, my lord? Maintenance of law and order has been continuously monitored and effectively managed by the ICR police, Itanagar police through area domination, patrolling, NACA checking, and preventive actions under the relevant provisions of law. In connection to recent law and order situation arising out of ABSU election, the following cases were registered. Altogether, 8 cases have been registered. Investigations promptly initiated and are being conducted in a fair and impartial manner. All the investigation formalities, including examination of witnesses, inspection of place of occurrence, and collection of evidence have been undertaken. Preventive and security measures have been strengthened to prevent reoccurrence of such incidents to ensure public safety. Then second is the deployment of police personnel and security arrangement. As per the requirement, 4 platoons of CRP have been deployed at Itanagar police station to assist the existing strength of the PS during any kind of exigency. In view of ensuing ABSU election 2026, more than 30 convoys and 2 platoons of troops have been deployed as part of law and order arrangement. Then the precautionary measures, 3. Precautionary measures in case of any untoward incidents or law and order situation during election. Series of coordination meetings were conducted at DIGP ICR office, SP office, ICR office, and SDPO Itanagar ICR with ABSU election committee members on 11/2/2026, 6/2/2026, and 3/2/2026 respectively for better coordination and peaceful conduct of election. As a part of preventive measures being taken, various contesting candidates have been bounded down under section 126 so-and-so of BNS to maintain peace and good behavior. Then a special branch and other sources have been engaged for intelligence gathering for advanced actionable inputs.
So, Mr. Sotori, it appears necessary steps are being taken to take care of the law and order situation if arises during the
This is very fine, my lord. I have heard, my lord, this is very fine. May I make a suggestion, my lord? The election is scheduled from 20th, that is tomorrow, to 26th. Let this matter come up on 26th, my lord. In the meantime, my lord, the affidavit will be exchanged, and on that date, you will consider it again. But my lord, on 26th, my lord, because they cannot declare the results before 26th. So, my lord, they do not declare the result, my lord. Let them hold the election. but let them not, my lord, declare the results, because, my lord, by the time the matter is taken up on 26, maybe, my lord, they may declare. So that protection your lordship may kindly give. That will not prejudice them also. Otherwise, my lord, they should be able to do the my lord, declaration of results only, my lord, after counting on 26th. So on 27th, perhaps, my lord, they'll declare the results. So, my lord, in any case, my lord, your lordship will give it, my lord, limited protection that till the next date, my lord, the matter is taken up on 26th, they will not declare the results.
Okay.
That will not prejudice them. In any case, they cannot do it also.
Okay. Yes, Mr. Kato.
Malad, objection to that part, Malad. Let the election be, Malad, go on smoothly.
The election will go on,
Malad.
but you should not declare the result.
Malad,
On 26th, your lordship will hear.
We will take up the matter on 26. Till then, you should not declare the result.
Malad, till just time, Malad, what my Malad, the submission will be, Malad. Let the matter be fixed on 26, Malad, itself, Malad. Wherever, Malad, it is necessary, Malad, lordship may, Malad, consider that aspect, Malad.
Pardon?
Malad, the matter may be listed on 26, Malad. Matter may be listed on 26, Malad. On which date, Malad, Malad, if Malad required, the lordship may interfere with the Malad election process, Malad. If there is any law and order problem, if it is not done as per the procedure, if it is not done by the Malad, complying the other Malad, the necessary procedure.
What Mr. Soto's contention is that till 26th of this month, results should not be declared.
Malad, therefore, Malad, my submission is to reply to that Malad, the point is Malad, let the matter be simply fixed on Malad, without Malad passing any such order, Malad, on 26, Malad.
No, but
on 26,
you have to assure this court that result will not be declared prior to 26.
Malad, even it is not known how many days it will take time to Malad cast their votes, Malad. Altogether, Malad, for 30 Malad 6 posts, contesting candidates are more than 78, Malad. 78
maybe
for casting Malad, for casting these 78 Malad candidates from top to bottom, Malad. And Malad, altogether 5,000 above voter list. Malad, it will take a week time to Malad ends the process, Malad.
No, why you are opposing in passing such an order that a result should not be declared prior to 26?
Malad, on 26, Malad, what I'm submitting is, what I'm Malad, bringing before your lordship is, let the matter be listed again on 26, Malad. On which date, Malad, by Malad, the affidavit will also become.
Okay, we will not pass such order, but you have to assure before this court that you are not going to declare the result.
Let him give an undertaking. But what I am apprehend, my lord, the way the notification has been now issued, my lord, they may say that on 20th itself all the voting has been completed and
when the election process will be end, my lord.
Declare the results.
As
That
I
is a
pointed out,
possibility,
Malad, more than 5,000 voters are going to Malad cast their votes, Malad.
Okay.
And Malad, again another problem is, Malad, as I pointed out, 78 candidates, Malad. More than 78 candidates.
That's all right. If you were not be able to declare the result prior to 26, that's all right. No problem.
Malad.
But prior to 26, you should not declare the same.
Malad.
On that undertaking, we are adjourning the matter. We will take it up on 26.
May I please, ma'am?
Yeah.
My lord, I have mentioned an IA.
Pardon?
I have mentioned an IA.
Yes, yes.
My lord, this IA is for impleading me as a necessary party, my lord, as a respondent number 7.
Who are you?
My lord, I am an aspiring candidate.
Pardon?
I am an aspiring candidate.
Aspiring candidate.
Yes, in this forthcoming election, my lord.
What is your pair here?
My lord, since I am an interested party in this ABSU election, my lord, so any outcome of this election of this court will highly prejudice me, my lord.
No, you see, this is PIL.
My lord, I may be made the necessary party since I'm an aspiring candidate, my lord.
Okay, we'll see.
My lord, in that case, may I, my lord, pray that, my lord, I may be allowed to take instruction over telephone, my lord.
In respect of?
In respect of what my lord, the submission made from the senior counsel that, my lord, on the, regarding undertaking, my lord.
Okay, you obtain instruction and apprise this court later on. We'll pass the order later on. But we'll not call the matter again.
My lord.
We'll list the matter on 26. Mr. Sururi.
My.
Yes, Mr. Sururi will list the matter on 26.
I am grateful, my lord.
Okay.
If the undertaking
my
is
lord-
not, my lord, then there is an order that till 26, my lord, they will not declare the results.
Okay, okay,
I'm grateful, my
My
lord.
lord,
okay.
may I please, my lord. My lord, if while listing,
See whether you are necessary party here or not. We'll pass order.
oblige, my lord.
My lordship, I beg to mention item number 9, lordship. I'm for the respondent. Item number 9. Lordship, here on the last one, instruction was sought from the department. I have not received yet, so 1 week time may be granted.
To inform the other side.
I've already taken consent from the other side.
Okay.
1 week.
Mr. T. Gatsa,
Yes, Lordship.
Learned Counsel. Learned Standing Counsel for the
Department of Horticulture.
Department of Horticulture with consent from the other side as for listing the matter after
1 week.
after 1 week. Fair allowed.
Deeply obliged.
My lord, may I mention item number 19? My lord, here I'm item number 19, my lord.
Yes.
I have received, my lord, the instruction. My lord, in fact, I contacted to, my lord, the HK Jamo, who is going to on behalf of the applicant petitioner, my lord. He is objecting, my lord, adjournment. My lord, however, my lord, my submission would be, my lord, I'm leaving for some urgent work, my lord. So therefore, my lord, my lord, what I'm praying for is, matter may be heard on, my lord, next Monday, and his submission may be heard, my lord. Today, my lord. He is pressing for the, my lord, the stay of the, my lord, the construction work. This is a, my lord, the army-based, my lord, the strategic important, my lord, project work. This road will reach to, my lord, the Vijayanagar, my lord, and other, my lord, the Parplang areas where security, my lord, the reason is, my lord, is, my lord, highly risk, my lord. So therefore, our early construction of the work is required, my lord. But my friend, my lord, the SK Jamo is going to appear on behalf of the petitioner, my lord. He is, my lord, objecting for adjournment today, my lord. He is going to press, my lord, for the passing of the interim order, my lord. So, my lord, my prayer would be, my lord, I may not be available, though my brothers will be there, my lord. But my lord, submission, advance submission is, my lord. No, my lord, they stay in this matter, my lord, is because the petitioner has already received, my lord, his compensation amount, my lord. And at this stage, my lord, if lordship, my lord, interfere in the, my lord, the execution of the work, my lord, it will be seriously prejudiced. My lord, it is not the case of the petitioners that he has not received single penny, my lord. He has received entire amount, my lord. Even the deputy commissioner.
What is his grievance?
His grievance is, my lord, some cardamums are still standing there, and then if, my lord, construction work is, my lord, start, my lord, that will be damaged and without assessment, my lord. He's asking for the assessment, my lord. But the deputy commissioner has already, my lord, rejected his prayer. No, you have already been paid. Compensation amount has already been received by you. Even you are in PEC, my lord, the assessment you are going to claim.
Okay.
So, my lord,
You ask someone to remain present.
my lord. So, my lord, at this stage, my lord, if interfere, my lord, the national importance will be, my lord, deeply obliged.
May I please, my lord? My lord, I'm praying for a listing of writ petition for tomorrow for withdrawal.
Please, Lordship. Lordship, I beg to mention item number 16. I'm appearing for the respondent number 4. Lordship, recently we have filed Wakalat Nama and
You are for respondent number 4.
in item number 16, Lordship.
Yes.
Lordship, recently we have filed wakalatnama and we need some time to go through the petition.
Okay.
Kindly matter may fix.
The other side?
We have taken consent from the other side, Lordship.
Okay. But you see, this matter is tied to the item number, no, this item number 15.
We have no information about item number 15, Lordship.
Okay. Sir, your name, please?
D. Tali.
D. Tali, Learned Counsel, appearing to the respondent number 4, submits that he has filed his wakalatnama when?
After 3 weeks, Lordship.
No, when you have filed?
Recently we have filed.
Recently he has filed the wakalatnama and he may be granted some time to go through the petition and to file the affidavit in opposition. Fair a lot, this is at least the matter after 3 weeks.
3 weeks, Lordship. All right, Lordship.
For item 15 also, not only 16. This order has been passed in item number 15 also, not only 16.
We'll see.
Item number 1.
May I please, Lordship?
Yes.
Lordship, this is a writ petition for regarding Lordship GST matter. Fact of the case, Lordship, petitioner is running a small business.
Running?
Yes, running a small business under TY Enterprises, Lordship.
Okay.
So for that, GST has been registered in the year of 2020, Lordship. It is annexed under Annexure A, Lordship, page 22. And what happened, Lordship? On dated 7/10/2024, there was so-called notice against the petitioner, Lordship, for the GST default, Lordship. So petitioner is completely unaware about this GST default, Lordship, because GST all credential login, this email ID and password was with the accountant. So because of some circumstances, Lordship, the communication was not with the accountant, so it could not be access the portal, Lordship. And subsequently, Lordship, 31st of December 2024, Lordship, there is a impugn order for the suspension and cancellation of the petitioner GST, Lordship. That is, Lordship, Annexure C. May kindly see the page number 26, Lordship.
Page number?
26, Lordship.
Yes.
Since Lordship, it was due of the liabilities for the 6 months, Lordship. So for that regard, petitioner GST has been already suspended from the superintendent of CGST department, capital region, Lordship. So Lordship, after that, I have managed new accountant and successfully access my GST portal, Lordship. Then I paid all the liabilities with penalty. 2024-25 December. And also, Lordship, February, till February, all GST, the liabilities had been already cleared, Lordship. That is Annexure, Lordship, B and E, page number 36 to 57, Lordship. So, my humble submission, Lordship, on parity, on dated 6/3/2026, this month, Lordship, there is a order from this honorable court. It has been already revoked. One same date, Lordship, same nature of case of this case. So my humble submission, kindly revoke the cancellation and suspension order of the GST by the CGST Department of Superintendent Capital Region, Lordship.
Yes.
Lordship, it can be passed on this motion only, with direction to approach them before the SP Itanagar, CGST. Since they had already filed all the return, with direction to revoke after examining the remaining, if there is any default. So with that direction, it can be. Lordship.
Okay. Pardon, sir, your name, please.
G. Gunia.
Learned counsel for the petitioner and also heard Mr.
T. Kipa,
Learned counsel for the
CGST.
CGST and
Itanagar.
you. Pardon?
I'm appearing on behalf of PSCI.
Union of India.
Union of India. Mr. Kato.
Yes.
Learned Deputy Solicitor General of India, Mr. Kato. Being respondent number here, your respondent number?
1.
Respondent number 1.
And I am for respondent number 2 and 3.
20. This petition under Article 226 of the Constitution of India, the petitioner has tried for setting aside and causing the order dated ZA 121222400 7896P dated 31st of July 2024, passed by the Superintendent of CGST Itanagar. And also tried for revoking and tried for issuing direction the respondent to revoke the cancellation of registration as ordered by the aforementioned impugned order dated 31st of July 2020, sorry, 31st of December 2024. The learned counsel for the petitioner submits that the petitioner is aggrieved by the impugned order dated 31st of July 2024, passed by the Superintendent of CGST Itanagar, whereby the GST registration of the petitioner was cancelled. The learned counsel for the petitioner further submits that the petitioner is running business as proprietor of the MSPY enterprise, Itanagar Industrial Area. That Itanagar Industrial Area, Sector in Aralavan, Papumpare. And due to loss of his login credential for the GST login, he could not access the GST credential. And after constant effort, he retried the login ID. And after getting the credential from of our login ID and password, he had filed all the GST return till the date of his cancellation, that is the December 2024. December 2024, and the said documents are annexed as annexer D and E in the petition. He also submits that though he has filed all his return till cancellation of the GST registration, the respondent authorities have not yet revoked the suspension order. And he further submits that in similarly situated matter in WPC number 86 of 2026, this court by order dated 6/3/2023, which is annexed with the petitioner's annexure number F, has granted relief to the petitioner by directing the petitioner to approach the respondent authorities by filing an application, and also directed the respondent authorities on such petition being filed to consider the same in accordance with the law and with further direction for restoration of the GST registration of the petitioner of that petition. And similar direction may be issued in the present rate petition also. The learned counsel for the respondent number 1, 2, and 3 also submits that they have no objection if similar relief is granted to the petitioners like petitioners in WPC number 86 of 2024. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on record. And from the annexer, when his registration was cancelled,
31st December 2024, Lordship.
that I ordered dated 31st of December 2024, annexer C, the GST registration of the petitioner was cancelled after issuing super's notice on 7/10/2024, which is annexed with the petitioner's annexer number B. Then it also appears from the annexer D series that annexer D and annexer E that the petitioner has already deposited, already filed the return and also deposited the penalty amount. And penalty amount. And from the annexer F, the order dated 6/3/2026 passed in WPC number 86 of 2026, it appears that this court was placed to grant this court having relied upon the decision of another coordinate bench of this court in Pankaj Mohan versus Union of India in WPC number 7342 of 2023, decided on 18th of 2025, has found that the petitioner of the WPC number 86 of 2026 are similarly situated with the petitioner in Pankaj Mohan, and thereafter granted the relief to the petitioner as granted in the case of Pankaj Mohan. And in view of the submission of learned counsel for both the parties and also in view of the order being passed by a coordinate bench of this court in 6/3/2023 in WPC number 86 of 2026, and also taking note of the decision dated 18/12/2025 in Pankaj Mohan case. Pankaj Mohan within brackets of this court is inclined to dispose of this petition by directing the petitioner to file a petition before the respondent number 20.
Yes, 20.
Within a period of 15 days from the date of passing this order for restoration of his GST registration, and on such petition being filed, the respondent authorities shall restore the GST registration of the petitioner in accordance with law. And the aforementioned exercise has to be carried out within a period of 4 weeks from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 2 and 3 within a period of 1 week from today. Terms of this Next.
Much obliged.
Item number 2.
My please, my lord. My lord, I'm before this honorable court being aggrieved by my removal from the post of a cashier UDC with a stigmatic order.
You were removed from the post or removed from your position?
In my position with a stigmatic order, my lord.
You are no longer in service.
I'm in service.
You are in service.
But the authority is not assigning me any duty now. Here, my lord, that this order was removal order was passed without holding any departmental inquiry. And Apex Court in the getting up decision held that when stigmatic order is passed, then
you were not removed from the service.
not removed from
You are
service.
still in service.
Yes. Here, my lord, the brief fact of the case that I have been, I'm serving as a UDC cashier at Daporaji Electrical Division since 2025. And on 4th of January 2025, I was assigned the charges of cashier also.
There was an inquiry, fact-finding inquiry.
Yes, my lord.
First, you have been issued so-called notice. Right?
I was issued so-called notice, but
And thereafter, fact-finding inquiry was conducted.
no, my lord.
Thereafter, you have been removed from that post.
My lord, here I was not aware of the fact-finding committee's constitution or any report or anything. There till that they are not furnishing the document. Earlier, I was served so-called notice alleging that I have furnished a document of appointment order or attendance roll. And with that regard, I have submitted a reply, which is, my lord, annexure 3.
Okay, let notice go at this.
And since, my lord, this kindly see the impugn order, my lord.
Annexure 2?
Annexure 4. And impugn order is annexure 4. Yes, my lord. May I read, my lord, 11%. Whereas a fact-finding committee was constituted to examine certain administrative matters pertaining to the functioning of this division. It's not with regard to, my lord, particularly for my misconduct or allegation. And whereas as per the finding of the fact-finding committee, a trust deficit has been observed within the division office under your incumbency, adversely affecting the smooth functioning of the office. Now, therefore, in view of the above finding and in the interest of maintaining proper administrative functioning, Sri Pagjam Niling, holding the post of cashier, is hereby removed from his present position with immediate effect until further order, my lord. My lord, observation made in this paragraph today that trust deficit and under my incumbency adversely affecting the running of the office, my lord. This is a stigmatic order, my lord. Seriously casting aspersion on my lord, integrity, my lord. And such order could not have been passed, my lord, without holding a proper departmental inquiry, my lord. Earlier, I have clearly explained, my lord.
You have not been, no punishment is imposed upon you. Had you been removed from the service, then the matter would have been quite different.
Yes, my lord.
But you are still in service. You are only removed from that post.
Yes, my lord.
The post of cashier and?
Yes. But if it had been, my lord, mere removal, it would have been different without this, my lord, allegations. When the authority is making this, casting this aspersion on my integrity, my lord, there has to be, my lord, regular inquiry, my lord. And Apex Court in the Ketina decision held that, my lord, when stigmatic order is passed, then there should be a normal, regular inquiry, my lord. If had been just a change of position, my lord, it would have been different, my lord.
No, there is no, no observation in respect of your integrity. It is only stated that a trust deficit has been observed within the division office under your
incumbency. Because, my lord, this is pointing at me, my lord, this trust deficit, my lord, and is unable to function, adversely affecting the smooth functioning.
Whether it would amount to any comment upon your integrity?
Yes, my lord.
How?
Apex court in my lord held that when employer expressed that they have lost the confidence in you and then pass order, my lord, that was considered as stigmatic, my lord. This is a similar, my lord, trust deficit, my lord. With regard, my
Let
lord,
notice go. Let them file affidavit.
my lord, my humble prayers that this operation of this order should be, my lord, stayed, my lord.
No, let
Otherwise, my lord, I am nowhere, my lord.
Let them file their affidavit. Then we'll finally hear and dispose of the matter.
My lord, now authority has removed me from position and not assigning me any
You are not
duties.
dismissed from the service, not removed from
dismissed.
the service. You are still in service.
Still then, my lord.
No.
My lord,
They
Apex
have
court
issued
hold
summons
that
notice to you. They have given no. They have inquired the matter, and there is a fact-finding committee report. Let them bring all those
my lord,
documents on
this
the record by filing affidavit.
my lord, I am totally unaware of this fact-finding committee constitution or their conduct of any inquiry. They have never, my lord.
This is not a departmental proceeding.
Yes, my lord. But behind my back, my lord, they cannot conduct a.
How behind your back? They have given notice to you, Soko's notice.
So-called notice, my lord, I have replied. And thereafter, but if the authority constitute a fact-finding committee, my lord, we have to be informed, my lord.
We'll see.
And behind my back, they have allegedly conducted, my lord, inquiry kind of
This is not a
inquiry.
departmental inquiry.
Not departmental inquiry, but
Then
they have made, my lord, this adverse comment against me, my lord.
Fact-finding committee.
Yes, my lord. Because
Yes,
fact-finding committee.
Mr. De Lade, learned counsel for the petitioner. Mr.
Yes, Your Lordship, on behalf of Elton.
Learned counsel appearing on behalf of Mr. L. Parnell, learned counsel for the respondent. All the respondents?
Yes, for power department.
Being respondents in power department. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order of removal dated order number DAED stroke E-21 stroke 2025-26 stroke 2108-13 dated 24/2/2026 passed by the Executive Engineer, Daporezu Electrical Division, Department of Power. Is to be noted here that by the impugn order dated so and so, the Executive Engineer, Daporezu Electrical Division has removed the petitioner from holding the present post of UD cum cashier without any justified reason. Mr. Ladvi, learned counsel for the petitioner, submits that the petitioner has been serving as UDA cum cashier at Daporezu Electrical Division, Department of Power, Daporezu. And by impugn order dated 24/2/2026, he was removed from holding the present post of UD cum cashier. Mr. Ladvi, taking this court through the order dated through the impugn order dated 24/2/2026, submits that the said order contains serious allegation of misconduct such as trust deficit within the division office under the incumbency of the petitioner, which adversely affect the smooth functioning of the office. And by making such observation in the impugn order, they have the respondent, the executive engineer has attached a stigma upon the petitioner's reputation and integrity, and the same has been done without holding any regular departmental inquiry. And under such circumstances, Mr. Lavi has contended to interfere with the impugned order. Impugned order. The submission of Mr. Lazi, learned counsel for the petitioner next further consideration. At this stage, notice be issued to the respondents returnable in 4 weeks, step by speed post. No formal notices. However, no formal notices required to be issued since all the respondents are represented by their standing counsel. However, extra requisite copy of the petition will be furnished to him during the course of the day. Recess leaves the matter after 4 weeks. Interim care of the petitioner will be considered on next day.
Item number 3.
Please, my lord, in this matter, my lord, here again, my respondent authority has released me on the basis of a transfer order, which has already been executed, which has already been complied, my lord, just to harass me, my lord. Here lately, I have been.
Has you have been transferred to Tirap?
Yes, my lord.
Kunsa.
Yes.
Thereafter, you have been posted.
Corrigendum was issued, and I was written at the headquarters.
And thereafter, they have released you.
Yes. Thereafter, I was given additional charge of Tirap. And now suddenly is issued the release order that alleging that stating that I'm in order to enable me to join the Tirap, no is releasing me. Here, my lord, secretary corporation has been lately subjecting me with a frequent transfer and my lord, harassment, my lord. Here, my lord, may I take...
say in the original transfer order, your posting was at Tirap.
Tirap, and wrongly showing that
attached you with the head office.
Yes, my lord. Actually, here, my lord, it was like that. Original transfer order is, my lord, page 13, my lord. There, I had been shown as a present place posting as a head office, and I was transferred to Tirap. Whereas at that point of time, I was not at the head office, my lord. I was posted at the Lower Subansiri District 0. And moreover, I had hardly completed 1 year, 5 months. After receipt of this order, my lord, I have submitted a representation stating that I am not in a headquarters, I am in 0. And I have just completed 15 months, my lord. Accordingly, my lord, representation is, my lord, annexure 2, not annexure, annexure 3, my lord. Here I have stated that I am posted at 0, I am not at the headquarters. And I also stated that I have been subjected to frequent transfer. Thereafter, after submission of my corrigendum representation, the corrigendum was issued, which is page 20, my lord. In partial modification of transfer order number, my lord, EB number dated 13 March 2025, the working station of Gaticoming DRC is appearing at serial number 3 of the said order shall be in the head office instead of Tirap district. Page 20. Thereafter, my lord, page 20 is the corrigendum. After this corrigendum, my lord, I have joined here at the head office by the joining report dated 1st April 2025, which is annexure 5, my lord. And thereafter, my lord, since I was discharging my duties with sincerity, my lord, with honesty, by the order dated 4th July 2025, I was given additional charge of DRCS Tirap, my lord. Annexure 6, my lord. I am at, my lord, serial number 5. additional charge of clearly reflected, my lord, additional charge of DRCS TIRAP, my lord. And by impugn order, my lord, Annexure 7,
You have been released.
I have been released, my lord, in compliance of the earlier order, my lord. Now, my lord, my contention, thereafter I have a submission, my lord, representation also, but same has not been considered. Now, my lord, case is that when earlier order.
Mr. Ladi, you say from 13th of March 2024,
Yes.
you are in the headquarters.
No, my lord. I was at 0.
No. Prior to that, you were in 0.
Yes, my lord. No, not prior to that, but I was at 0. Then 13 March 2024 order is issued, my lord, by showing me as at a what headquarter.
And when you joined that headquarters?
I joined headquarters after issuance of the corrigendum, my lord.
Corrigendum was issued on
25 March 2025, my lord.
Yes.
27 issued on 27.
So what wrong with this order?
My lord, I was transferred initially to the TIRAP, but that was modified and I was headquarter. Now I am working at the headquarter in compliance of, my lord, earlier transfer order, which is modified by the corrigendum. From 0 I have come to the headquarter. Now the respondent authorities is releasing me from headquarter in order to enable me to join at the TIRAP without issuing fresh transfer order, my lord. On the basis of the earlier transfer.
Order has already been issued.
No, my lord.
In the year 2024.
That was, my lord, after corrigendum, that was, my lord, modified, partial modification.
That's all right. But originally you have been transferred to TIRAP.
Yes, my lord.
So now they have released you.
But, my lord, that order has been modified by the corrigendum, my lord.
Yes, that was modified.
Yes, my lord. And then
you have been posted, you have been attached to the head office.
Yes, my lord. Now, my lord, after issuance of this corrigendum, my lord, earlier transfer order ceased to be exist, my lord. That cannot be, my lord, cannot have any force, my lord.
No. Whether such kind of indication is there in the corrigendum.
Corrigendum, my
partial modification of the transfer order.
Yes, my lord. And this subsequent order clearly shows that I have been given additional charge of the TIRAP, my lord. And
Mr. Nabam?
My lord.
You see the release order last, Annexure 7. And thereafter the corrigendum. And thereafter the transfer order.
My lord, release order talks about the earlier transfer order, the original transfer order, madam.
No,
Then-
you see the wording of the corrigendum in partial modification.
Yes, madam. Partial modification of, my lord,
transfer
order dated 13 March. The 13 March is the original transfer order, madam. Now, as per this release order, my lord, since, my lord, they have nullified or they cancel or they revoke this corrigendum order and giving effect to the original transfer order. Now, my lord, the original transfer order is not under challenge, which is the genesis of the case. This is not under challenge. What he challenged is, my lord, the release order. If you lordship see the release order, my lord, somewhere in February, we are in March, my lord. 1 month, almost 1 month after his lordship. Having said that, my lord, we all know, my lord, transfer and posting is the essence of service condition.
That is there.
Now, my lord.
No, you see his contention.
His contention was, my lord, frequent transfer.
No. His contention is that the earlier transfer order stands modified. by issuing this corrigendum.
My lord.
And therefore, the earlier order ceased to exist.
Yes, now
It is his contention.
correct, my lord. If that be so, my lord, if your lordship see the original transfer order, my lord. Original transfer order is page 13.
Annexure 1.
Annexure 1, my lord. This is 2024. Right, my lord? Now, what my friend is saying, my lord, 2024, he was not in headquarters. Right, my lord? Headquarters means Naharlagan. He was in 0. Right, my lord? That is contention. 2024, he was in 0. Now, let's see, prior to 2024, where he was, my lord. You let me kindly see, my lord. Page number 15, my lord. This is order dated, has your lordship got it, my lord? This is order dated, my lord, 20 October 2023. My lord. Present place of posting, head office. He should have been 0, my lord, as per his version, my lord. So meaning thereby, right from my lord, 2023, even 24, my lord, he was in headquarters, my lord. Although, just a minute, subject, my lord, he was given additional charges. If your lordship see, my lord, the 2024, 13 March, the first transfer order, extreme right, remarks, will continue to hold the additional charges of AWF Limited. So AWF Limited, my lord, this must be in 0, man. This post. So he was allowed to hold additional charge at 0 also, man.
But he was working in.
But he was in headquarters. He was in headquarters. If that be so, where is the question of frequent transfer? Right from the, no, what your annexure you have given, this is your document, this is not my document, madam. 2023. The place of my posting, head office. Transfer to where, my lord? This is relief from so and so shall continue as MD, AP, Weber Foundation Limited, headquarters 0. So this was in my lord. Additional charge he was given. He was not at 0, my lord. How can you challenge, my lord, say that no, the place of posting is there. The place of posting, my lord, is a head office, my lord. Head office is Naharlad, my lord. So the question of frequent transfer does not arise, my lord. Now, my lord, coming to, my lord, the main question, my lord, after, my lord, corrigendum, can you give, my lord, retrospective, my lord, effect to that original transfer order, my lord? My lord, here also it says, my lord, in partial modification transfer order, event number so and so, the working station, my lord, the lordship may kindly note, working station of series so and so, DRC, appearing number so and so, shall be at head office instead of trader. His working place, my lord. Working station, my lord. Working station. So meaning thereby, that is the reason, my lord, why he was given additional charge of Tirab also, my lord. So that he can look after, my lord, Tirab also, my lord. So my concern, my lord, would be, my lord, not to tell him, my lord, we have forgone the original transfer order, my lord. Perhaps this must be a temporary arrangement, my lord. So that's why, my lord, this release order, if your lordship sees, my lord, as your lordship got it, page 24, my lord. In continuation, my lord. The vote said, in continuation of earlier, my lord, corrigendum, issued file number so and so. This even talks about the corrigendum also, my lord. That has been perhaps, my lord, revoked, and the original transfer on stand. That's why, my lord, he has been asked to, my lord, he has been released already, my lord. He has been released on 27 to 2026, my lord. So almost a month, my lord. Honorable is to join the place of posting Consa as DRCS Tirab by the issue number so and so, file number so and so. This is 13/3/2025. This is the original transfer order. And this is not challenge for lordship. This is the genesis of my lord's his releasing order.
So he put to have been challenged the 13th March of 2024 order.
Yes, man. Even the transfer original order, the subsequent release order. Both ought to have been released, my lord, challenged, my lord. Suppose if your lordship, my lord, suspend this release order, the original order remains, my lord.
Yes.
The transfer order remains, my lord, which is not under challenge. And otherwise also, my lord, in SL Abbas, my lord, the law has been laid down. There are certain parameters where the read court can intervene in transport matter. Must be a malafide. There must be violation of any statutory provision, my lord. There is nothing is there any sort of malafide, my lord. They have not said anything about the violation of any constitutional provision or my recruitment rules. Could perhaps prohibits the authority or the transferring authority incompetent, my lord. Nothing like that, my lord. I don't find any, my lord, illegal in this, my lord, release order, my lord.
My lord,
That is my submission.
in compliance of original order, which was modified by corrigendum, I have joined here at headquarters, my lord. Once corrigendum is issued, my lord, that original transfer order doesn't survive, my lord. It cannot be revived by issuing this release order, my lord. Because that transfer order has been complied.
No, the word supersession is not there in the corrigendum.
But modification is there, my lord.
Had it been there,
Yes.
then the position would have been different.
Yes, my lord.
But
transfer order.
We have used the word in continuation, my lord.
Modification, my lord. Modification is modified, and it clearly shows, my lord. I was earlier transfer order has been cancelled, and I have been written at headquarters by this my lord 4th July order, my lord, which is Annexure 6, where I was assigned additional charge of my lord the TIRAP. If original transfer order was surviving, then how can I hold that as additional, my lord? That was to be my substantive posting, my lord. But this 4th July order clearly indicates that earlier order was complied.
This unless you challenge the original order, this Annexure 1, by challenging the release order, no purpose will be served, I think.
My lord, earlier order is not surviving. That is come to cease to exist on the instance of corrigendum.
No. You see the wording in continuation.
In continuation. But my lord, this is not a transfer order, my lord. This is a release order, my lord.
No, therefore, transfer order is Annexure 1.
Annexure.
And that is not the subject matter of challenge in this.
Yes, my lord. Because that order is no longer existing because after my joining at headquarters, my lord.
No.
That order doesn't exist, doesn't hold the field, my lord.
Had the word in supersession been used, then the position would have been different. Now it says that in continuation, it means that the original order remains.
No, my lord. My lord, kindly try to appreciate this release order. This is not a modification of transfer order again. This is a release order, my lord. Earlier corrigendum was a modification of transfer order, and the present order is a release order, my lord, not a transfer order. Since, my lord, this supersession would be clear by my lord coming to this, my lord, this order, my lord.
No. The word supersession is not there.
Not there, my lord. From this order, my lord, to clarify that I have been written at the headquarters, and I was given additional charge of my lord Dhira. Kindly come to page 22, my lord. Serial number 5. Sri Gati Koving DRCS, DR3. Additional charge of DRCS Thirap, my lord. If earlier transfer order were existing, then how can I could be given additional charge, my lord? Earlier transfer order come to, my lord, cease to exist. That's why, my lord, this order was given. I was given additional charge of my lord. DRCS Thirap.
No.
Now my substance.
No. You see the remark column.
Yes, my lord.
Of the order 13th of March 2024.
Yes, my lord.
Will continue to hold the additional charge of AWFED.
Yes.
Limited.
My lord. Yes, my lord. That's, my lord, altogether different, my lord. I was posted, new posting place was indicated DRCS Thirap, my lord. This was modified, my lord, by corrigendum, written at headquarters, my lord. And I was given my lord, additional charge of TIRAP subsequently by 4th July 2025, my lord. If earlier transfer order were surviving, my lord, there's no question of me, they giving me the additional charge of DRCS TIRAP, my lord.
No, they can, it can be.
My lord, if
It can be.
if my lord, if I wear, my lord, if I wear DRCS TIRAP, my lord, as per the initial order, my lord, then
No, though the order has been passed, you have been attached to the head office.
yes, my lord. My lord, orders is modified and head office, my lord, I was given additional charge, my lord. This is my lord, new.
Thereafter, you have been the transfer order has been modified by issuing this corrigendum.
Yes, my lord.
Then you were attached with the headquarters
Headquarter, my lord.
with additional charge of
DRCS.
DRCS of this TIRAP.
TIRAP, my lord. This additional
Thereafter,
charge.
you have been released.
And my substantive post is, my lord, not the DRCS TIRAP, my lord. Even, my lord, kindly try to appreciate this order. My substantive part is DRCS DR3 at the headquarter.
Anyway, Mr. Lazi,
Yes, my lord.
let notice go.
My lord, if impugno order is
Another option is there. You should ought to have challenged this order also.
my lord,
Annexure 1.
my lord, to my understanding, my lord, Annexure 1 is no longer surviving, my lord.
No.
Issuance of,
No. This has not been superseded.
my lord, kindly try to appreciate this order of 5th July, my lord. 2025, subsequently passed after the corrigendum, my lord. Please, my lord, see what's in this order, what they've indicated, my lord. My substantive post is Sri Gati Goving DRCS DR3, my lord. This is my substantive posting, my lord. Additional charge of DRCS TIRAP, my lord. It clearly shows that at that point of time, I am not the DRCS of TIRAP, my lord.
Agreed, my lord. No one is
Agreed.
disputing. That's why, my lord, you are released in 2026.
No, my lord. This cannot be, my lord.
Why not?
Transfer order, which
Why
is
not? You have been given additional charge, my lord. Additional charge, just to look after, my lord.
look up there, but I cannot be sent there.
Why not?
Because that is not my substantive place of posting, my lord.
My lord, why he is forgetting, my lord? We have reactivated the original transfer order, my lord.
This,
The lordship may kindly say, my lord, what he is happening to 4th July 2025. Serial number 5, petitioner, my lord. He was giving additional charge. What he is saying, my lord, he was never, my lord, been to TIRAP, my lord, holding the post. My lord, agreed, my lord. That's why, my lord, we have released on 2026, my lord. The 25th February 2026. So that he can go to TIRAP and take a full charge, my lord, in compliance to the transfer order, my lord. Then what's the wrong, my lord? Nothing.
my
wrong
lord,
with
the
that, my
difficulty is that this subsequent release order is not a transfer order. This is not a modification order of the transfer
Nothing
order.
wrong with that.
This is only release order, my
Okay,
lord.
let notice go at this is.
My lord,
But
if
we'll keep the question of maintainability open.
my lord, if this order is not interpreted, my lord, if they will send my salary at TIRAP, my lord, which is the extreme eastern corner of the state, my lord.
Obviously, you have been already released, my lord. You have been already released, my lord.
But I have not been transferred, my lord. No praise transfer order has been issued. Earlier transfer orders come to cease to exist with the issuance of my lord, corrigendum and my joining at the headquarter. If they want to wish to transfer me, they can issue praise transfer order, my lord. But not on the basis of this old order which has been complied, my lord.
Transfer order in the year 2024 remains.
With regard to other, it remains, but in respect of me, my lord, that ceased to exist on the issuance of the corrigendum, my lord.
No. Corrigendum, by issuing this corrigendum, you have been attached with the principal, with the head office.
My lord, moreover, in this case, there is no reliever, etc. In time being, my lord, may I kindly suspend this operation of this order because
There may not be reliever in all the cases.
but my lord, here
Your superior officer may hold the search.
but the things that, my lord, if I'm released, my lord. If this order is not stayed, my lord, that will cause great hardship to me, my lord. There is no, my lord. There is no any, my lord.
Transfer is a condition of service.
But there is no transfer order, my lord.
That annexure 1 is already there.
Really, my lord, that and annexure 1 has ceased to exist, my lord, on issuance of corrigendum, my lord.
Sir R.S. Nabam, learned additional advocate general for the state respondent.
All, my lord, 1 to 3, my lord.
Kindly, my lord, try to notice, my lord, this corrigendum release order also, they have referred not the original transfer order, my lord, which my brother has wrongly said.
No, in continuation, what is there?
That is the corrigendum, my lord, which that referred the date of the corrigendum, my lord. Even number that is 25/3/2025, in continuation of earlier corrigendum, my lord.
Issued by the order number same, file number same, dated 13/3.
This petition under Article 226 of the Constitution of India, the petitioner has challenged the release order dated 25th of February 2025, issued by the Secretary Cooperation, Dr. Burnasal Department of Cooperation, Itanagar. Mr. Lade, learned counsel for the petitioner, submits that the petitioner is serving as Deputy Registrar of Cooperative Societies, DRCS, and presently posted at the head office, Narlagan. He also submits that earlier he was serving as Managing Director of AP Waivers Federation Limited at Zero, pursuant to transfer order dated 20/10/2023, and he was transferred to DRCS by transfer order dated 13/3/2024, where his place of posting was erroneously shown as head office, Naharlagun instead of Zero. And thereafter, the respondent authorities have issued one corrigendum on 25/3/2025, directing the petitioner to serve at the head office, Naharlagun. And pursuant to the said corrigendum, the petitioner has joined his duty at head office, Naharlagun, on 1st of April 2025. And while he was discharging his duties at head office, he was released by impugned order dated 25/2/2026, purportedly in his place of posting. No, from his present place of posting, purportedly in compliance with the earlier corrigendum, which was already issued and implemented. And being agreed, the petitioner approached this court by filing the present petition seeking the relief as aforesaid. Mr. Lade further submits that the earlier transfer order, Annexure 1, stands modified by corrigendum dated 25th of March 2025. And as such, the earlier transfer order dated 13th of March 2024 ceased to exist. But he has been released by impugned order dated 25th of February 2025 without bearing any fresh transfer order. And as such, the impugned order is illegal and arbitrary, and it would cause serious hardship to him, and therefore it is contended to stay the impugned order. However, Mr. Nabam Learned, Additional Advocate General, has vehemently opposed in staying the impugned order, and he submits that the original transfer order dated 13 March of 2024 still exists, and the same has not been superseded. And though corrigendum was issued the petitioner was attached with the head office, and subsequently in by impugn order dated 25th of February 2026, he has been released so as to enable him to join at Iraq. The submission of learned counsel for both the parties needs further consideration. At this stage, notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Nabam entered appearance and received notice for all the respondents. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter after 4 weeks. And having regards to the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is not inclined to grant any interim relief at this stage. List after 4 weeks.
In that case, my lord, my lord, if interim is not granted, my lord, if I'm released, my lord, the matter will automatically become in practice, my lord, since this is a release order, my lord.
No, you failed to demonstrate that you are going to be prejudiced, or your transfer is in contravention of any rule or regulation.
My lord, what I'm saying is that there's not existing valid transfer order, my lord, because earlier transfer order has come to, my lord, cease to exist, my lord.
We'll take care of
till,
the
my lord,
final-
till returnable date, my lord, at least, my lord, because no prejudice will be caused to the parties, my lord.
But in another line, however, this impugn release order is subject to the outcome of this petition.
Very well, my lord.
Item number 4.
My lord,
Most
I
of
am
the-
appealing to VC, my lord. My lord, impugn order is at page 20. I have been compulsorily retired, my lord. And page 20, my lord. And kindly see, my lord, the words they have used, lack of integrity, ineffectiveness. And after using these words, they have not given me any opportunity under section 311. It's a clearly on the face of it, it is a clear stigmatic order. And opportunity ought to have been provided to the petitioner to give his explanation if they at all wanted to use these words like lack of integrity and ineffectiveness. The rule FR 56J1 they have used, it was so simple there, my lord. Due in public interest. Rule says nothing, notwithstanding anything contained in this rule, the appropriate authority shall, if it is of the opinion that it is in the public interest so to do. It was so simple for them. They could have written compulsory retired in public interest. That would suffice. But they have come and they have used these words, lack of integrity, ineffectiveness, making this order stigmatic on the face of it, and no opportunity under 311. As such, my lord,
Okay, that's all right.
Yes.
But you see, this impugn order was passed on 27th of September 2022.
My lord.
Today we are in 2026. This petition is filed after 4 years.
Yes, sir.
How do you explain the delay and losses?
Paragraph 16, no? My lord, it is there. Paragraph 16, we have already explained, my lord. Paragraph 16, my lord, he was in jail, my lord. He was facing multiple accusations, allegations. He was arrested in cases. He was later on granted bail by the High Court, then Apex Court. And then, my lord, he was having financial constraint. He had suffered through a lot of things, my lord. And he has come now. And my lord, this is a violation of the constitutional right. And my lord, when there is a violation of constitutional right, he should be given an opportunity, even though he has come up late. And we have specifically stated why he had to come up after 4 years at paragraph 16, my lord. And my lord, when there is a violation of constitutional right, delay, my lord, plays no role, because constitutional right of a citizen has to be upheld. Delay, question of delay, my lord, in that aspect cannot be a ground for dismissing a writ petition, my lord. That is my humble submission.
Whether your argument is based on any decision of the Supreme Court?
Yes, my lord. Supreme Court have held in many cases that when it is fundamental right, delay has a delay cannot be a ground for dismissal.
Which one is your fundamental right here?
Article 311, Article 14, 15 is that 21, my lord, they have compulsory retired, my lord. Then, my lord, 311 is there, my lord. They should have given me an opportunity of being heard if they are questioning my integrity.
Is Article 311 is a fundamental right?
That is a
Whether fundamental right is granted by Article 311?
That is a constitutional right, my lord, granted, my lord, 311. That is my constitutional right. I am a public servant and I have that constitutional right under 311 that they cannot.
And how your fundamental right is violated?
My lord, the moment I am compulsory retired, my lord, my salary and everything, my lord, stopped. I have been shown the door. Immediately 21 comes in, my lord, right to life. My entire course of life has changed, my lord. They have retired me. They have put me out, my
No,
lord.
you see, they have invoked the FR 56.
Yes. My lord, 56.
So your dismissal order is under FR 56.
FR 56. But words used are not as per FR 56. Lack of
You first
integrity.
you first satisfy this court about the delay and losses of 4 years in filing this petition.
Kindly take up paragraph 16, my lord.
You produce the decision of Supreme Court. We'll see.
Yes, sir. Punto. Will settle the power of High Court. My lord, then I'll place the decisions if required, my lord.
Yes, we will fix another date.
My lord, on the delay and losses, my lord, on that particular point.
Yes. Heard Mr. F. Khan, learned counsel for the petitioner. Mr. Tagum for
I'm for respondent number 1.
respondent number 1. Madam Nani for
2, 3, and 4.
2, 3, and 4. And Madam Ite for
4, 5, 6, 7, and 8, Lord.
5, 6, 7, and 8. It appears that the impugn order, it appears that the order impugned in this writ petition was passed on 27th of September 2022. But the same has been impugned in this petition only in the year 2026. There is delay of almost 4 years. Mr. Khan, learned counsel for the petitioner, has to satisfy this court the delay and losses in this writ petition on next day by producing decision of Supreme Court. List on suggested it.
Data person, data. Oh, hard foot ki baat aswa. My lord. On 3rd of 1st April or 3rd April, my lord.
3rd April is holiday.
1st of April, my lord.
Okay, 1st of April.
Okay. 6th.
6th. You will not be available.
No. 6th, I am not there, my lord. Kindly, I am sorry, my lord. Then any March.
Let it be on next week.
Yes.
Next week? Next week.
6th of April.
6th of April.
Okay. 6th of April.
My lord, 6 of it.
Okay.
Grateful,
Right.
my lord.
Item number 5.
Yesterday instruction was short form.
What's it? Also, it seems even with yesterday that it will be automatically protected also. Here.
So the case has been disposed of.
Yes, Lordship, and based on Lordship, general principles, Lordship, regarding that appellate court, the petitioner, Lordship, pleading that he could not have passed the sealing order, Lordship. Here I on general principle, Lordship, I would like to say that under specific circumstances, Lordship, order the sealing of an unauthorized building, even if it was not part of the original pleadings or the lower authorities order, while the appellate court generally restricts itself to the issues raised, it has the authority and duty to act when a significant illegality is brought to its attention or discovered during the proceedings. Therefore, if the appellate authority discovers that a building is unauthorized, it is not restricted by the scope of lower authorities' initial order and can order the building to be sealed. This is based on general principle, Lordship.
General
Right. Lordship. It is there. So, Lordship have seen the photographs also, Lordship. In between the, thereby uprooting the fencing and causing serious Lordship damage to the other the existing quarters and inconvenience to the dwellers here. Lordship. So I added Lordship this repetition may be dismissed on this ground. And let the building be sealed and the procedure be taken up by the concerned authorities. Proper procedure.
Yes.
Yeah, my lord. My lord, let admit that, my lord. This order at page 21, my lord, is a final order passed by the ADC state officer, my lord. Page 21, my lord. Let admit it, my lord. This is a final order. But, my lord, and against this order, my lord, in this order, my lord, the petitioner was directed to construct a boundary wall, my lord, retaining wall, my lord, for the protection of all, my lord. Against that order, my lord, appeal has been prepared, my lord, by the respondent number 4, my lord. Now, my lord, if, my lord, the learned ADC state officer, my lord, fails to exercise his jurisdiction, my lord, as given under the Act, my lord, what, in my humble submission, my lord, Deputy Commissioner would do, my lord, ought to have done, my lord. He has to send it back to the remanded it back to the state officer and directed him to, my lord, proceed in accordance with law, my lord. That is his, my lord, power, my lord, in my humble submission, my lord. Otherwise, my lord, as for section 12, my lord, he has no power. My lord, for a moment, my lord, assuming, my lord, he has a power, my lord. Assuming, my lord, the London Deputy Commissioner, who is an appellate authority, he has a power, my lord. But, my lord, for that also, my lord, he has to follow a procedure, my lord. My lord, in this case, I fairly submit, I'm not on merit, my lord. I'm harping on procedural.
Whether this order was passed without giving you an opportunity of being heard?
Which one, my lord? My lord, this impugn order, my lord.
Yeah.
My lord, kindly. Section 7, my lord. Sealing order is.
I am asking you,
Yes,
you
my lord.
answer my query.
My lord,
Whether you have not been heard before passing this order?
my lord, I have to give 7 days time, prior notice, my lord. Notice, so-called notice has to be given to me. Thereafter, a date should be fixed.
No, here this order is passed in appeal.
Yes, my lord. My lord, I was there, man. I was there.
Then?
I was there, my lord. But
You
my
have
lord,
given the opportunity of being heard?
my lord, I was summoned, my lord, has kindly come to the summon letter, my lord. When it was summoned.
You answer my question.
I was there, my lord. This is not disputed, my lord. I was there, my lord. But
You
my
have
lord,
heard?
my lord, as for the order, I have been heard, my lord. As for order, my lord.
Who was there, Lord?
Since I was there,
He was
it can be.
present there.
But my lord, as for my lord, we have to go through the premise of the act, my lord. But even if we assume that this London Deputy Commissioner has power, my lord, to seal my building, my lord. But before that, he has to, my lord, follow certain procedure, my lord. Whether that procedure has been followed or not, that has to be seen by this honorable court, my lord, also. But I'm, my lord, assuming also for me. Can we come to, my lord, section 17, my lord, volume 8, section 7, page number 165. 165. Page 165, section 7, ma'am. Roman 1, my lord. Married, ma'am. Where the erection of any building or execution of any work has been commenced or is being carried on or has been completed on any public premises by any person in occupation of such premises under an authority, whether by way of grant or any other mode of transfer. And such erection of building or execution of work is in contravention of or not authorized by such authority, then the state officer may, in addition to any order, any other action that may be taken.
No, this has to be followed by the state officer, not by the appellate authority.
That's why, my lord, this has to be followed by the state officer. But, my lord, where is, my lord, this power has been given to the, my lord, appellate authority, my lord. My lord, even we assume that appellate authority has power, but he has to follow this, my lord. Provided, my lord, there is proviso also, my lord. Provided, my lord, no order under this subsection shall be made unless the person concerned has been given by means of a notice, not less than 7.
Here you have been heard.
But, my lord, where is the notice, my lord? Before that, I directly.
No. You were in the appeal.
Yes, my lord. I'm not the appeal. I'm the respondent there in this impugnment, my lord. And I have been, my lord, summoned directly, my lord. No notice has been served, my lord. I have been summoned directly, my lord. Someone was.
No. What is the purpose of giving notice? If you have been summoned, if you have entered appearance, is it not amount to issuing notice or summoning you?
My lord, in my humble, my lord, in my humble understanding, my lord, summon and notice is, so-called notice is two different things, my lord, in my humble understanding. Because, my lord, if notice has been issued, I have filed a written reply, my lord. Written reply.
I have been summoned. I have been only
No,
summoned.
you see whether you have produced any order of granting permission to construct the building,
My lord,
whether you have produced any NOC.
that's not on that.
Pardon?
Not, my lord.
Not.
Not. But in substance, my lord. My lord, we cannot travel beyond the act, my lord.
Yeah.
Beyond the act, my lord. Act what it says, my lord.
No, whether the appellate authority has traveled beyond the act.
Yes, my lord. My lord, this sealing order has to be passed by the state officer, my lord. As for the act, my lord. My lord, section 12 clearly speaks, my lord. And that
No, you first tell me that the appellate authority has no such authority to pass such order, sealing order.
my lord, section 12, my lord. Section 12 clearly speaks, my lord. How does appeal lies to the London Deputy Commissioner? It said that any order passed under section 5, 7, 8,
Yes,
and 10.
being agree with the order passed by the
Yes,
ADC,
yes, ma'am.
passed by the ADC, that lady has preferred the appeal before the appellate authority.
That's why, my lord. That's why I'm submitting, my lord. But London, as an appellate authority, ought not to pass this order. He has to remand back the matter to the London state officer, my lord. After quashing this order, my lord,
Why
21.
should we? Why should he remand the matter to the ADC while he has the power?
Because he cannot pass the sealing order, my lord, as for section 7, my lord. He cannot pass, my lord. He has to remand the matter back to the state officer. That is the, my lord, crux of this act, my lord. In my humble understanding, my lord. In my humble submission, my lord.
No,
Yes.
where it is provided in the act about the remand.
My lord, since, my lord, as per the, my lord, this act, my lord, since,
Where it is provided, you show me the provision.
my lord, kindly come to section 7, my lord. It say about the state officer who has to pass the order, my lord, of sealing order, my lord.
No, maybe whether the appellate court has no power to pass such order.
My lord, it doesn't speak about his power also, my lord. In my humble submission. It doesn't, the
No,
act doesn't.
you first you first understand what is the power of the appellate court. Yesterday, the counsel for the other side has pointed out one provision of the CPC.
My lord, CPC, in my humble submission, CPC is not applicable in this my public premises act, my lord. On that, my count, my lord, if they are arguing on that point, my lord.
But the street.
Yes, my lord. If they are saying that CPC is applicable in this public premises act, my lord, I need some time to review that argument, my lord.
Pardon?
I need some time to rebuttal that argument. But I am saying that CPC is not at all applicable in public premises act, my lord. It is a special act, my lord. There is a special stated, my lord. The CPC cannot be act, my lord. It cannot be, my lord, applicable in this special statute.
No, on what basis you are submitting that the procedure prescribed in the, no, not the procedure, but in respect of that power. That's what is provided in that section of CPC.
My lord, regarding CPC, my lord.
Regarding power of the appellate court.
Regarding power of that. My lord, since, my lord, section 12 clearly speaks, my lord, and my lord, section 7 speaks, my lord, if I humbly, my lord, submit, my lord, in my lord, civil revision petition, my lord, when civil revision petition will file before this honorable court, my lord, the order can be set aside, but the civil, this honorable court will remand the matter back to the, my lord, the trial court, my lord, subordinate court.
Civil revision petition, the scope of the court is limited. The court examine only the legality, property, and correctness of the order.
My lord, that's why, my lord, here in this case also, my lord.
In revisional power and appellate power are two different powers.
That's true, my lord. But in this, therefore, in this case also, my lord, the London Deputy Commissioner ought to have remanded the matter back to the state officer, my lord. Not
No,
pass.
you show me any provision that the deputy commissioner is not entitled to pass such order.
My lord, sir, I'm extremely sorry, my lord. For that, I need some time, more time.
Okay. We'll grant you time. Heard Mr. Lampo, learned counsel for the petitioner. And Ms. Ite, learned additional senior government advocate for the state respondent number.
Lots of 1, 2,
1,
3.
2, 3.
1, 2, and 3. And Mr.
Appearing on behalf of G. Riga, private respondent number 4.
Mr. So, your name?
Same company.
Learned counsel appearing on behalf of Mr. Z. Riba. Learned conducting counsel for the respondent number 4. 4. Pursuant to order dated 18/3/2026, Ms. Ite has received instruction and apprised this court that the case number DC-ICC-17013 Scrub 21 Scrub 2024-JUD has been disposed of by the previous additional deputy commissioner ICC. Mr. Lampo, learned counsel for the petitioner, at this instance submits that he may be granted some time to apprise this court about the power of the appellate authority.
My lord.
And price for listing the matter. When?
Can it be on 20th April, my lord?
23rd?
20th April.
20th April. 20th April. In that view of the matter, this case released from the partner.
My lord. My lord, interim order is there, my lord.
The instruction produced before the court today by Ms. Ite shall be marked as annexary and be tagged with the record. Interim order passed earlier shall continue.
Lordship, since this court has heard enough about this matter, can it be kept part heard, Lordship?
No, but this roster is only for 27th of March. Thereafter, therefore.
All right.
Okay, next item.
Item number 6.
May I please, Your Lordship, matter regarding non-payment
Lordship,
of salary.
Before
as per
my senior
decision
starts, Your Lordship, I would like to take adjournment in this case, Your Lordship, on behalf of senior government advocate, Your Lordship, as Tapin. He has some difficulties, Your Lordship. He has some personal difficulties. Can it be on 30th, Your Lordship? After a week.
Heard Mr. Gogoi, learned counsel for the petitioner. And Ms. Basar, learned counsel, learned government advocate appearing on behalf of?
As senior government advocate, S. Tapin.
Mr. S. Tapin, learned senior government advocate. And she submits that Mr. Tapin has some difficulties today and press for listing the matter on 30th.
30th, Your Lordship, after a week.
Press to list the matter on 30th. Please.
Appeal, Lordship.
No, March.
March 30th.
March 30th, Lordship. 31, Lordship.
31 won't be possible, Your Lordship.
Lordship.
30. He will not
Not
be
be
there on
30,
31.
30, Lordship.
30.
Okay.
Item number 7.
May I please, Your Lordship?
Yes.
My Lord, the IS first. I have filed 2 IS.
Okay.
These two IS are for striking off parties. IA number, the first one, 63/26, is for striking off the petitioners number 21 and 22. Lordship, since they were in really in need of money, so they had accepted the compensation. This case is for compensation, Lordship, for reassessment. So they had made some sort of assessment which we were agreed with. That's why they had come as petitioners. But now, since they could not wait any longer. They simply accepted whatever was given. So therefore, they would no longer be petitioners. Petitioner number 21 and 22 in IS 63. Same thing, Lordship, in IS 74 is petitioner number 7. Your Lordship would need to pass orders in this first, then Lordship may come to the main case.
Okay. Any objection?
No, my lord.
No.
No.
Heard Ms. N. Dengen, learned counsel for the applicant, then also heard Mr. R.S. Nabam, learned additional advocate general for the state respondent.
1 to 4.
1 to 4. Then Mr. Sadok for respondent number 5 to 6. 5 and 6. This interlocutory application is preferred by 2 applicants, namely Sri Zampi Payeng and Simoti Likhanemi, who are the petitioner number
21 and 22
in WPC number
504.
504 AP 2025. 520. Ms. Dengen, learned counsel for the applicant, submits that though the applicants herein have filed the applicant herein has filed the WPC number so and so as petitioner number 21 and 22, yet they are now not interested to pursue the said petition, and they have also received the compensation amount.
They have accepted
the compensation amount awarded by the respondent authorities, and as such, their name may be struck off from the array of the WPC number 504 of 2025. Mr. Nabam and Mr. Zadov submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The name of the applicants be struck off from the array of the writ petition number so and so as petitioner number 21 and 2022. Same order in 74 AP 2020. Here, who are the applicants?
Petitioner number 7.
7.
Yes.
Only one.
Only one.
7. Okay. Only one. Same order. Yes.
And my lord, in the main petition, the WPC 504, since the pleadings are complete, we have also filed a reply and all lordship. It's needs to be urgently disposed of. So if it can be heard today.
You want to file?
No, we have already filed.
You have filed.
We have filed everything. Pleadings are complete. May I pray, lordship, that this may be taken up for disposal now, lordship.
But you have to file this amended cost title.
Lordship.
Technical problem.
Technical problem. Can it be on Monday then?
Lordship, sorry.
Monday you will not be here.
Lordship, in that case, maybe fixed after some time because I will be out of stations from tomorrow. From tomorrow for quite some time, Lordship.
Quite some time.
Yes. Lordship,
Don't fix Wednesday.
Lordship, after 3 weeks then, Lordship.
After 3 weeks.
Yes.
Heard Ms. Daniel, learned counsel for the petitioner, and also heard Mr. Nabam, learned additional advocate general for the respondent number 1, 2, 3, and 4. Mr. Zadov for 5 and 6. 5 and 6. Mr. Dengen submits that in this matter, pleadings have been completed and the matter may be listed for admission hearing. Here allowed, recessal is the matter after 3 weeks. And in the meantime, Ms. Dengens and shall file amended cost title of the
Lordship, since we have been actually trying for interim order, but it could not be done for some reason or the other. So if it is fixed on the next listing, it may be given, it may be taken up for disposal, Lordship.
an endeavor will be made to finally hear and dispose of the matter.
Obliged.
Item number 8.
Yes.
Your Honor, respondent has yet to file a affidavit.
Respondents have not yet filed their affidavit.
Yes, Your Honor.
Okay. Art Minister, your name, please.
Tinima.
Learned
NIMA.
Counsel for the petitioner and Madam for
I'm appearing on behalf of DSGI Amicable for respondent number 1 and 2, Your Lordship.
Miss, your name, please.
O Jerang.
O Zedang, Learned Counsel for the appearing on behalf of Mr. M. Kato, Learned Deputy Solicitor General of India, and Mr. Rirampo. 325. 325. Who has not filed the affidavit? You?
Your Lordship, I have also not filed.
Okay. You want to file or you do not want to file? You want. The Learned Counsel for the respondent submits that they may be granted some time to file the affidavit in opposition. They are allowed, recessal is the matter after 2 weeks? 3 weeks. After 3 weeks.
Much obliged, Your Lordship.
Obliged.
Item number 10 and 11.
My lord, item number 10 and 11 is a connected matter. Conducting counsels B. Kosik could not appear today due to some personal difficulties. So matter may be listened after 2 weeks.
After?
2 weeks.
After 2 weeks. Heard, Mr.
A. Bonia.
A. Bonia, Learned Counsel appearing on behalf of Mr. B. Kosik, Learned Conducting Counsel for the petitioner, and Mr.
Lordship, I'm S. Sirang.
S. Sirang.
Yes, in item number 11, I'm for the petitioner. For the appellant. Item number 11.
In 10, you are not a party.
No, Lordship.
Yes, who is the party in here?
In item number 10, 10 revision review petition, here we are petitioner. In item number 11, in respondent, we are representing respondent.
Item number
11.
For respondent. Here, who are the respondent?
Domlong Pangkam. And another.
Are you not the respondent here?
Lordship, we don't have any instruction.
Okay.
Service report taken.
None appears to the respondent on call. Recessal is the matter after
2 weeks.
After 2 weeks.
Item number 12.
Sorry.
May I please, Your Lordship?
Yes.
Your Lordship, I have filed an IA, Your Lordship, for implement of me as a respondent number 6 in WPC number 287, Your Lordship. And just now I have received a reply with regard to this IA, Your Lordship.
My lord, we have filed the reply today. So,
any objection?
Yes, serious objection. My
Why?
lord. We will need some argument, my lord. So, can it be taken up tomorrow, my lord, for argument? We have serious objection because it is a matter, this dubious claim for this implicit matter. He is not actually an interested person. So, he is not actually an interested person. He has no locus to join here.
Okay,
So our hearing will be taken tomorrow, my lord.
tomorrow.
Your Lordship, hearing may be, this is just for implement, Your Lordship. So even now, hearing can take place, Your Lordship.
No,
Because-
if he is not ready, then you have difficulties tomorrow.
No, Your Lordship.
No,
Yes.
let us fix the matter tomorrow. So the question is whether you have claimed any relief against them.
No, no relief. But Your Lordship, since I'm a public spirited person, Your Lordship, and I'm a bona fide like villagers of that particular place, Your Lordship.
No,
So- Your Lordship, for proper execution of this writ petition, Your Lordship, proper execution of this.
No.
Only that is the only ground they have said this made here, my lord. Only for the proper adjudication of this writ petition, their assistance is required, unless this honorable court would not be this good enough to adjudicate it. My lord.
Is it the test?
That is the only ground that they have.
Maybe.
My lord, there's a younger sister has just received their affidavit in opposition, and she requires some time to prepare and counter the argument as put forward in the affidavit in the opposition, which they have raised. Lord. So just grant at least a week time so that
Tomorrow.
Tomorrow?
Yes, Your Lordship. Tomorrow.
No, you say the Supreme Court has set down guidelines.
Your Lordship.
Which a party may be implicated in a proceeding.
Yes.
Find out those judgments of the Supreme Court.
Your Lordship, only on my instances only that their LPC eviction notice, all of them were issued by the Forest Department, Your Lordship. So that is why, Your Lordship.
No, maybe this is the writ petition is not a public interest litigation.
No, Your Lordship.
WPC number 287.
Yes.
Okay.
Otherwise, tomorrow, Your Lordship.
Tomorrow.
Yes.
Hard miss. Your name, please.
A. Talom.
Learned counsel for the applicant, Mr. Zamo for the opposite party. Mr. Zamo submits that he has. And Madam, you are here?
In repetition, for all the respondents.
Okay. Mr. Zamo submits that he has filed objection petition. And he pressed for listing the matter tomorrow. Fair allow presses a list the matter tomorrow.
Item number 13 and 14.
Please, Lordship. Lordship, in this matter, Lordship, without going into the merit of the matter, Lordship, since the party, Lordship, the petitioner and the respondent, they have settled the matter amicably, Lordship.
Okay.
And they have jointly filed an application before the Deputy Commissioner, that is respondent number 2, Lordship. So we are simply seeking a direction from this Honorable Court to consider the application filed by the parties after they are being agreed for the settlement, Lordship. They have filed the application before the Deputy Commissioner, Lordship. That may be considered, Lordship.
Okay.
In WPC,
we will close this petition by directing the Deputy Commissioner to dispose of your application.
Application, Lordship.
Joint application.
Joint application. Joint application.
I also have the instruction, Lord, same instruction that both the parties. I am petitioner in writ petition number 247 and respondents number 7 and 8 in 352. That's item 14. Lord. So just client has given me an instruction that they are from
Both are connected.
connected matter. So
13 and 14.
Yes,
okay.
the clients they are from the same party. There is claim and counter claim for compensation of 66.68 square meter of the land, say hectare of the land.
17
Yes.
points.
So now what had happened is out of that 17.62 hectares have been acquired by the NHPC, and then already compensation amount has been deposited before the deputy commissioner. So both the party engaged themselves in a mediation. They engaged in a mediation and finally settled. So, and accordingly, they have submitted a joint application on 2026. And our instruction is, my lord, to make a prayer before this honorable court to direct the deputy commissioner to consider the case.
Item number 14. You are petitioner in WPC number 352.
Yes, Lord.
And you are in the other
Respondent number 7 and 8 in
Here.
352.
Here.
Yes.
Okay.
And I'm petitioner in 247.
Okay. Mr.
Maro, it's very good, my lord, since they have already settled, my lord, amicable solution. It's very good, my lord. And as they have submitted, my lord, joint representation has been submitted for the deputy commissioner, which I am not aware, my lord. I believe, my lord, that officer of the court, my lord, they are telling the truth, my lord. Yes. Your lordship, without going into merit, your lordship, direct the deputy commissioner, my lord, you will consider, my lord, the representation submitted by the.
No, we will not comment on the merit of the petition.
Yes, yes, Lord.
Simply, we will close this petition, directing the deputy commissioner to dispose of the application
Whatever, my lord,
filed by
representation.
both the parties.
Yes, Lord.
Part, Mr. Learned counsel for the petitioner, and Mr. P.T. Tara, learned counsel for the respondent number
7 and 8.
7 and 8, and Mr. Nabam for respondent number.
My lord, I'm 1 to 5. Then 1 to 5 in my lord, WPC number
1 to 5.
1 to 5. That is my lord, item number 14, my lord, WPC number 247.
No, no,
Right?
I'm in 13 now.
13, my lord, I'll be representing 1 to 5.
1 to 5.
Same.
And madam, you? Respondent number 6. NSPC. NSPC. And also heard Mr. T.T. Tara, learned counsel for the petitioner.
In item 14, read petition number 247.
247, AP 2025.
No,
And
respondent.
Mr. Yu?
Yeah, they are not there.
We are not responding in that.
Or not respondent. And Mr. Nabam, you are here as respondent number?
Same, 1 to 5, my lord.
1 to 5. And you for? Respondent number 6. P.K. Theory, learned counsel appearing on behalf of Mr. P.K. Theory, learned conducting counsel. The learned counsel for both the parties submitted at the bar that the dispute between the parties have already been settled amicably, and they have jointly filed an application before the deputy commissioner.
Yes, on 17/3.
Deputy Commissioner
Deputy Commissioner.
Deputy Commissioner Roing.
Dibang Valley, Lord Dibang.
Lord Dibang Valley, Roing.
Lord, kindly 819 in connection with a plot measuring 66.68 hectares acquired for construction of Dibang multipurpose project by NHPC.
In respect of a plot of land measuring
66.68 hectares.
66.68
hectares.
68 hectares.
Acquired for construction of Dibang
acquired for construction of Dibang Valley multi-purpose project
by NHPC.
By NHPC. And it is further submitted that the parties are not willing to pursue these two writ petitions, and as such, the same may be closed by directing the Deputy Commissioner Roing, Dibang Valley District, to dispose of the joint application filed by the petitioner and respondent hearing before him.
Therefore, particularly for a land measuring 17.62.
No, already mentioned it.
No, this settlement is only for 17.62 out of 66.68.
Okay. In respect of a plot of land measuring
17.62.
17.62
out of
hectare.
hectare.
Yes.
Out of 66 point 66.
Out of 68.88 hectare. 88 hectare. Let the process exercise be carried out within a period of
3 days.
3 days? No, not so fast, my lord. My lord,
2 weeks.
my
7
lord,
days, 1 week is enough.
just a minute. My lord, they will submit this certified copy, my lord, to the deputy commissioner, my lord. After that, my lord, within 15 days. 15 days. I think they are reasonable.
Sir, 7 days is good
7
enough.
days is good enough. Since the money has been already deposited.
So,
before the account
that's
of the
only
deputy
there was a claim,
Okay.
counter claim by both the parties,
My lord,
and money has already been deposited. And application, the joint application dated 17/3/2026
Well,
has already been.
why I'm saying, my lord,
Pass the direction in this way that after a week from the date of receipt of certificate copy.
Correct. That is fine. So
Then the petitioner shall obtain a certificate copy within a period of 1 week from today.
Yes.
And plus the same before the
Lord,
deputy commissioner.
Yes.
why I'm saying, my lord, because financial closing is coming, my lord.
Financial.
No, sir, but this is
No. Why I'm saying, my lord, deputy commissioner, my lord, he being the head of the district, my lord, he carries multiple purpose, my lord. That's why 15 days is not, my lord, I think it's a reasonable time, my lord, 15 days. Because since your lordship is directing to dispose of, my lord, and he has to go, my lord, both the, my lord, joint application, my lord, or the submitted, my lord. It need be, my lord, if there is any controversy, he may go for hearing also, my lord. That may take time also, my lord. So 15 days time, I think is quite
Why hearing is necessary? Both the parties have settled the issue.
we don't know, my lord, tomorrow may come third party also, my lord, because money is very dangerous things, my lord. Money is very dangerous thing.
This, in fact, this litigation has been pending before this honorable court from the last 3 months, Lordship. So no third party has been appeared so far. And Lordship, after meeting with the deputy commissioner by the parties, Lordship, even the deputy commissioner has said that
15 days is quite reasonable.
No, sir. Let the parties have settled, my lord.
All right.
My lord, one thing.
Your settlement is all right, but
My lord,
about you lordship to see, my lord.
My lord, if I will have to respectfully agree with the view expressed by learned additional AG, my view is this, Lord. This is a central government fund. It is nothing to do with
state exchequer.
Thereby the March, the question of 31st March, nothing will come.
Very well. My lord, one thing is clear, my lord. Money is not going to left, my lord. As per my lord. So money is not going to left. That's my lord. 15 days is quite reasonable.
My lord,
money is not going to left.
Mr. Nabam, you see, since they have settled the matter, let it be settled as soon as practicable. Otherwise, again, someone will come.
Yes, Lordship.
My lord, that is the reason why
my lord, I've said, my lord,
arbitration
is quite enough.
it is reasonably known in our legal parlance. Arbitration is a good mistress to deliver justice. My lord. So therefore, within a week period.
Not always, my lord, not always.
After receipt
Not
of the
always,
certified
my lord.
copy,
I'm sorry.
Lordship, after receipt of the certified copy by the deputy commissioner within 7 days. That's it, Lordship.
Within a week.
Yes, Lordship.
I will not consider to that, my lord. I seek for reasonable. Because if there is any failing, they'll come for contempt, my lord.
Sir.
They'll come for
Okay,
contempt.
10 days. Within a period of 10 days from the date of receipt of certificate copy of this order, the petitioner shall obtain a certificate copy of this order and place the same before the deputy commissioner hearing within a period of 1 week from today.
Lordship.
We are grateful.
We believe.
Item number 17.
Dear Lordship, I may be allowed some more time to file our affidavit, Your Lordship.
Affidavit not filed.
Yes, Your Lordship.
Third miss,
8th alum, Your Lordship.
8th alum.
Yes. Your Lordship.
Learned counsel for the petitioner, Mr. V. Jamo, for the respondent, no, Riram for respondent number
1 to 5, Your Lordship.
1 to 5 and Mr.
Respondent number 7. We can find out the case.
Learned counsel for the respondent number 7. Mr. Riram submits that he may be granted some more time to file affidavit in opposition. Fair allowed, recess shall list the matter after 1 week or 2 weeks?
1 week, Your Lordship, because Your Lordship, the project is going on, Your Lordship.
2 weeks, Your Lordship. 2 weeks, Your Lordship.
10 days.
Yes.
10 days.
Obliged.
Much obliged.
Item number 18.
Please, my lord. My lord, item number 18 is the IA that we have filed for clarification and modification of the order, interim order passed by this honorable court.
My lord, if I may, with the consent from my learned senior counsel appearing for the respondent, we can hear the main petition today itself, my lord, because the ground put in the IA is similar to the ground they have given in the written objection in the affidavit in opposition. Therefore, we can dispose of the main petition itself, main WPC itself today.
No, that main WPC is not listed today. What is listed is only the IA.
Okay.
Who are the applicant? You.
I'm in the main. I'm the petitioner.
You are the petitioner in main petition.
Yes, my lord.
Respondent number 3 is the applicant, my lord, in the IA.
What is the pair in this IA?
My lord, my prayer is a limited one, my lord. We are not challenging the interim order per se, but only seeking clarification and modification to ensure that it is not misused or alter the nature and character of the undivided property and for the ends of justice, my lord. My lord, in the last order, my lord, in the interim order, my lord will find the interim order in.
Got it.
Yes, my lord.
Paragraph number?
Last bit. Having heard the submission made by the learned counsel appearing for the parties and also considering the documents placed on record, a prima facie case appears to be made out for the staying of the impugn order dated 16/5/2023. Accordingly, the impugn order dated such and such passed by the learned deputy commissioner, West Siang district, shall remain stayed till the returnable order. My lord, now what's happening is with this interim order, the petitioner is accumulating materials and starting to erect a building there in the disputed land. My lord, this stay order does not grant or permit him to alter the disputed land, my lord. So, my lord, the applicant here.
You see, this interim order is very much clear.
Yes, my lord.
Here we are staying the impugn order only.
Yes, ma'am.
16/5/2023.
Yes.
What clarification is required? What modification is required here?
In the impugn order, my lord.
Yes.
The ADC has passed an order saying that status
That
quo.
order has been stayed.
Yes, my lord. Now we.
Status quo, Deputy Commissioner has passed status quo order.
Yes.
That order has been stayed.
Yes.
Since that order has been stayed, they can go with the construction.
My lord, that plot of land is a disputed one, my lord. It has not been divided by the head of the family as yet. The respondent number 3 also has a share on that disputed property, my lord. So, my lord, since the stay order, the status quo order has been stayed by this honorable court. Now, the respondent number 3 is remediless, my lord.
My lord.
There are chances of, my lord, breach of peace, my lord. The petitioner is unilaterally constructing the building over the disputed land. There are other brothers as well who has an interest in the disputed land, my lord.
What documents are there to substantiate your submission?
Photographs, my lord.
No. No, to substantiate that the applicant has also interest over the right title and interest over the disputed land.
My lord, the land belongs to my father, and petitioner is my brother, elder brother. And the land of the property, that property, disputed property, has not been divided my father till he was living. It is still undivided property. We all have the share over the land. Me and petitioner as well, and my other brothers as well. And the petitioner also knows it well, my lord.
My lord, admittedly, it's a case between two brothers, but the Tumpak Karga, who's the father of both the petitioner and the respondent, has passed away. And thereafter, the house that has been constructed is for the mother, and that is also not denied by them. That is, it's been constructed for the mother. Now, when there's an undivided property, then we're building a house for the mother. After the passing away of the father, the mother is the head of the house. So therefore, the house is being for the mother, and there should be no objection from the respondent.
But there is, my lord, the applicant, the petitioner started the construction when the father was still alive. The father had the objection, and
There's no document, no?
But
There's
a complaint was filed before the ADC when the father was still alive, my lord.
My lord, this complaint was filed by the impugn complaint was filed by the brother, my lord, not by the father.
Let us do one thing. We'll finally hear and dispose of the writ petition.
Yes, my lord, that can be done.
Say that.
Yes, my lord.
Can it be on next Wednesday?
Yes, my lord. No objection.
Check कर लेगा क्या? उधर में है क्या?
The house has already been half constructed, and there has been no dispute as of now. And the house is clearly, they also know it that it's been constructed for the mother.
Brothers only.
Yes, my lord.
Why don't you settle the matter amicable?
My lord, we have tried, my lord. This matter has been referred to mediation, and we have appeared for it. But the other party has not, my lord.
My lord, can it be on the 26th?
26.
Yes.
Okay.
26th.
As agreed by learned advocates of both the parties, rest shall list this interlocutory application along with the WPC number 259 of 2023 on 26th of March.
Yes,
on that day, an endeavor will be made to finally hear and dispose of the matter.
Much obliged, my lord.
Deeply obliged.
Item number 19.
May I please, my lord?
Yes.
My lord, this IA has been filed challenging the recent order of a DC where the construction of over my land has been permitted. Why this? We are challenging this order dated 9 March 2026, which is at page number 16. Type copy is at page number 17. We're asking for stay of this order. While, my lord, in a very brief manner, in the main writ petition, we have challenged the order of the Deputy Commissioner to 2024 order, wherein our representation has not been looked into, and in a very arbitrary and mechanical manner, it was declared null and void. My lord, it is a matter of compensation. We received the compensation, but however, we have asked to the authorities for re-verification and then quantification of the land. Thereafter, release of the differential compensation. My lord, in the re-verification, our land, I'm a cardamom farmer along with my family members. So what happened is only the land.
What is your interim PR here?
For the my lord, at this is at page number page number 5 of the IA. This operation of this order dated 9/3/2026.
That order is at page number?
Page number 16 is the type copy is at page number 17. My lord, if this order is allowed, what happens is my writ petition becomes infructuous because this BRO will carry out all the construction activities and the plot of land which is still there, which still needs a verification. That what will happen is the authorities will say there was nothing else remain. So to protect my land, at least to show that
Your land was verified. Verified earlier.
yes, but again, it was re-verified, and that re-verified report is not been accepted by the deputy commissioner. That is why this writ petition, after a series of writ petition, even a contempt petition, thereafter this third round of litigation.
No. Once it has been verified and compensation has been paid.
Yes.
What is the question for second verification?
Because the earlier verification did not took the whole scenario of my horticultural and other things.
Was it not conducted in your presence?
It was, but we put the representation, and that's why we went into writ petition. After the writ petition, our representation was considered another verification. That was 18/4/2022. And that become finality after the judicial order in the earlier writ petitions. So that 18/4/2022 order was not complied by this deputy commissioner. That is why we are asking for quantification, recalculation, and then distribution of the differential compensation. That is not yet been done. So now, if this land is allowed to be constructed,
What is the order of this court?
my lord, in the main writ petition, this is. It starts at Annexer 5, page number 77, 79. 77. Seven. My lord has got it. My lord, the operating portion will be at page number 79. May I read? As the Deputy Commissioner Anjao District would be looking into the grievances raised by the petitioner with regard to the incorrect entries made in respect of his land, that means petitioner, in the ground survey of private land starting from Chaglagam 6.5 km to Kapapu 16.5, acquired for construction of defense road by Gref. The letter that is so written by DC Anjao District to the Director Land Management Arunachal Pradesh Wide Order Number such and such, annex and to the shall not be given effect to till the representation submitted by petitioner is disposed of by the Deputy Commissioner Anjao as herein above. Thereafter, we submitted the representation. Thereafter, another Annexure 12, 101, 106. Another petition was filed. The order starts from 101. And operating portion is, my lordship, 106. Here, our compensation was determined in view of the above, the impugned bill dated such and such 2020 and impugned estimate bill such and such, which was presented on board proceeding number 20, stand set aside. Accordingly, it is directed that the according authority, more particular respondent number 4 shall deposit the assessed amount of rupees 35 crore 1,935 only in the account of DC Anjao. Respondent number within period of 1 month, and thereafter, my lord, this amount we again request for recalculation. This amount we also challenge Thereafter, another writ petition at Annexure 15. Annexure 15 starts from page number 113. We have challenged the order of the DC whereby, my lord, page number 114. Married. Heard Sri T. Pertin, the learned counsel for the petitioner, who has put to challenge an order dated 22/12/2023 issued by the DC Anja, whereby a certain amount has been assessed and directed to be deposited in the account of beneficiaries pertaining to acquisition of land. It is submitted that there is checkered history, including previous litigation, and in one of the litigation, the said authority by way of affidavit had made a statement that the assessment would not be done by taking into consideration a fresh survey report. The learned counsel submits that a reading of the impugned notification would not disclose that there has been a consideration on the fresh survey report dated 18/4/2022. We are here for 18/4/2022, which has not been considered by the DC. That is why this writ petition. After notice, but this in the last paragraph, this court, however, makes it clear that this court has not put any embargo on the disbursement of amount in question, which, however, will not cause any prejudice to the rights and interest of petitioner in this petition. Thereafter, this 18/4/2022 report is where it is what our contention is, that it has attained the judicial finality. This report 18/4/2022 is in the main petition. This is at page 89 to 94, man. Annexure 9, 89 to 94. Annexure 9 starts from a letter to the ADC, forwarding letter from the Chairman Verification Assessment Committee. And this is the report which we are relying on, which is after that, thereafter a contempt petition was also filed. There also that the concerned DC agreed that they will comply with this report of 18/4/2022. Ground survey verification report after all this series of litigation, wherein our claim has been clearly reflected that due to a large cardamom plants which was not feasible to all, and that our claim has been it is even a video description was taken on that day. So these are the chainage where the petitioners claim on the basis of this report of 18/4/2022. So at this stage, my lord, actually, if all the instruction are received, or if this respondent number DSG, आप लोग एफिडेविट फाइल किए? If the state respondents can file their affidavit in opposition at the early date, then I will not press for this IA also. But only thing is that,
Pardon?
If the state respondents can file their counter affidavit on a shorter date, then I will not press for this IA for this latest order of 9/3/20. No, will not press.
File it. Yes, my lord. We'll try, my lord. Within 10 days, my lord. I'll try to file it, my lord.
So, my lord, the difficulty is
that this is infrastructure project, huh?
Yes.
Work is going on, my lord.
Order.
Yes.
Then the construction work will be halted.
Yes, ma'am. Work is still going.
That is there, my lord. But however, my lord, if the whole land scenario will be changed, then my writ petition will become infructuous. Tomorrow they will say that there was nothing. That is the difficulty. Still, my cardamom, some of my horticultural items are still there. Our livelihood will be lost if the whole scenario landscape will be changed.
No, that has already been assessed.
Yes, my lord.
Then where is the question?
My lord, if again tomorrow if a new order comes for re-verification, then my lord,
No.
nothing will remain.
Question of re-verification does not arise, no? If already it is verified.
Yes, my lord. Short date, my lord. I will file my appeal.
Well, till the returnable debt,
Sorry, this is infrastructure project. We cannot stay in that way.
I understand, my
That
lord.
manner.
I'm also of the same view, my lord. However, my lord, if the landscape will be changed,
This project is of national interest.
yes, my lord, rightly observed, my lord.
So within 1 week you file the affidavit.
But my lord, if the whole landscape change, my
No.
enforceable
It
right,
has already been assessed. Then the question does not arise.
my lord, the DC, the DC is saying ki we are not going to comply with the 2022 order. That is why we have come up with
No.
the
Assessment was done, my lord.
No, you have already submitted that there was one contempt petition
yes,
where assurance was given to comply with that order.
yes.
Then
Thereafter, again, they are not complying. That's why we come up with the writ petition. That impugn order here is, my lord, just 5 minutes, my lord, just 5. Annexure 21, page number 134, second last page of this. This is the impugn order. 134, this order we have challenged. My lord, here the DC, in a very arbitrary manner, has clearly stated that he will not. Our
page number?
second last 134, 135 of the main petition.
Yes.
My lord, I'll just read the last paragraph below, page 134. My lord has got it. Findings of the boards. I'll read from the requiring agency 116 RCC grave has excavated land for the construction of Chaglagam Kapapu Road, kilometer chainage number 16.5, approximately 13 kilometers. Extensive damage has been caused to horticultural crops due to land cutting, excavation, and dumping of excavated material along the valley side. A significant number of large cardamom plants were buried under the debris. A realistic and accurate assessment of horticultural loss is not feasible on the ground, as the extent, quantity, and size of the crops cannot be determined due to complete disruption and burial caused by the excavation of kilometer 13.5. Next page. In reference to the verification report submitted by the earlier board, so-and-so, 2000, the subsequent report received by the board, the board examined and heard Sri Bachin Flakam GB and Sri Tasasu GB of such and such village on the spot. They stated they have no idea about the receiving compensation related to estimated dated such and such. This is also part of our petition. The board further recommended that estimate bills number 126 of Sri Mapigam Tega and his relatives, that is us, the petitioners, be declared null and void, as compensation had already been received for the same plot of land. But our case is not that we have not received the compensation. Our case is
the observation made in the foregoing para, you see?
yes. Preceding paragraph. In view of the above facts and after thorough perusal of both board reports referred to here, it is found the claim made by are not genuine because these are the subsequent boards. These are not authorized by this honorable court. Our case is 18/4/2022. The subsequent boards. That is why we have challenged this subsequent board report in this main writ petition. How come? Because in the contempt petition they said yes, we'll comply with the verification record 18/4/2022. If my lord, I've read that 1822 order, which is at annexure 9 of this petition. Yeah. So yes, my lord. So the subsequent these concern, this is relying on the subsequent verification report, which is why
the DC should disbelieve this subsequent board report.
That is our case.
No, why he should disbelieve it?
There is he has not given any reason for it. That is why it's a very arbitrary manner.
What reason is required? It is stated that they have no idea about the receiving of compensation.
Yeah, this
related to
GBs, my lord, regarding this Gamburas, because earlier there was an allegation that we received the the DC has in his one of his report reflected that some other person has already taken compensation on the same plot of land. That is why these GB statements are there.
That cannot be allowed.
Yes, my lord.
That cannot be allowed.
Yes, my lord. So we are challenging this particular order also.
As of now, there is no stay order.
Yes, no, my lord, we in the main writ petition, we never ask for any stay of this construction
Let's
activities.
file affidavit. Next week we will take it up.
But can it be in a fixed date
Yes,
on 1st of April or 2nd of April?
yes, yes, yes. Heard, Mr.
HK Jamo, my lord.
H.K. Jamo, learned counsel for the petitioner, Ms. Wang Mo for the respondent number
124, my lord.
124, and Ms. Learned counsel for the
M. Kato, DSGI.
M. Kato, appearing on behalf of Mr. M. Kato, learned counsel, no, learned deputy solicitor general of India. Respondent number 5 and 6. Ms. Wang Mo submits that she may be granted
10 days, my lord.
10 days time to file counter affidavit. Accordingly, taking note of the submission of Ms. Wang Mo, it is provided that recessor lays the matter on first of April is
2nd of April.
2nd of April, may I?
2nd of April, okay. 2nd of April. 2nd of April. So as a fixed item. On that day, endeavor will be made to
Dispose of the main.
dispose of this interlocutory application number 72 AP 2026 and the WPC number 8 of 2026.
Highly obliged, my lord. Highly obliged.
My lord, in item number 18, in the main writ petition, interim may be continued, my lord. If that much obliged, my lord.